till 60 is the theme, half of which your lordship has done. The theme is actually withholding assent simpliciter. Justice Narasimha doesn't have it. My lord has got that. 2.2, my lord, my submission. Yes.
Page 5.
2.2, 533, which is small page 54. My lord will use the small page. 54. Justice Suryakant has got it. So 6 pages till page 60 is the issue of withholding assent simpliciter, which otherwise colloquially we are calling falling through. Falling through. Now, my lord, I will not read these 6 pages because half of it your lordship is done.
60 is simply withholding.
Assent simpliciter, withholding assent simpliciter, which we are discussing along with the falling through concept. Falling through is not a head by itself. It's the withholding simpliciter category, which is also linked to falling through. Now, instead of reading these 6 pages, 3 of which I think your lordship has already read, let me, to focus, give your lordship 6 bullets of my entire argument on falling through. At this point, lordship may do me the favor of noting it down, just to 2 lines each, because that will be focused. It's dealt with in these 6 pages. Number 1, falling through is not an independent argument, obviously. It is a simpliciter withholding explanation. That's 1. So you have to see it in the light of, is there a category of simpliciter withholding, which my learned friend also describes as falling through? Is there a new separate category of withholding simpliciter? Number 2, the falling through occurs unless the first proviso is completed, is what those 2 judgments mean. The falling through occurs unless the first proviso is completely followed. Point 2.
So their argument is,
He just holds it back.
yeah,
And doesn't have to return it.
hold
Correct.
it back, and even if you don't follow,
Correct. I'm answering that. So, my answer is no. The falling through occurs only when the entire first proviso is not followed. There is no falling through by holding assent back and not sending it back. And let me explain my third point, how that happens. The first proviso is a complete code in itself. And it involves compositely and telescopically the following steps: withholding and returning back is one telescoped composite step. Withholding, assent, and sending back, returning the bill, is one telescoped composite step.
holding and
Returning, I mean, let's call it sending back. I mean, just, we are not using constitutional terms, just sending back is one composite step. Second, reconsideration by the House is step 2. All a complete code. The framers have thought of it and put it in the first proviso.
what was the second thing?
Reconsideration by the House, the
Reconsideration.
Assembly.
Yes.
Third, repassage by the Assembly. They are linked, but I'm separating them.
Passage or repassing?
Repassing, I mean this, repassing, correct, repassing by the Assembly.
By the legislature.
Legislature.
Simply because it could be.
Legislature.
If it is a bicameral house.
Correct. And returning to the Honorable Governor. Now, there are innumerable actual cases and perfectly understandable, that's my fifth point or fourth point, that the Assembly may not want to send it back, may not want to pass it,
Then it would
may have a change in policy, may decide to completely modify it out of identity. I mean, your lordship doesn't have to consider all the possibilities.
only in that event it will fall.
It falls through. Naturally, it falls through. And frankly, it can fall through even at the last of those stages. We have considered it in the Assembly, but we don't want to pass it again. It happened, Malus. So many times the bills are withdrawn. That is the way in which, that's my point number 4. Point number 5. All the judgments cited by Mr. Mehta are not falling through the phrase. They're all followed unless the first proviso. If my Lord recollects, I hope my Lord recollect. I'm saving time. Those 2 judgments have falls through unless the first proviso. It says so.
Unless the first proviso is followed.
That is the meaning which I've given. The first proviso following is this.
Their argument, unfortunately,
The first step, he says, is an independent step of withholding, no returning back. That's where he makes the break. The short point is, Mr. Mehta makes, according to my respectful and humble submission, an artificial break at keeping it locked in his cupboard and not sending back. Then the 6th reason was,
according to him, if the governor decides to withhold it and keep it back, then it will automatically fall.
Then all these steps, the proviso is not necessary. In fact, back to the assembly reconsideration, assembly repassing and sending it back. All these stops at the first stage. That's for a lordship ultimately, but the constitution is not going to say everything. Otherwise, Manoj, your lawyers would be superfluous and constitution benches also would be superfluous. Now, Manoj, the next point on the bullet. Next.
The last point is only if the assembly does not pass it.
Yes. In these various forms.
For variety of reasons.
Okay,
then only it will fall through.
And no, the last point was that the 2 cases he cites for falls through, my Lord recollects, Kameshwar and Valuri. My Lord remembers it, my Lord has read it in my. All say falls through, immediate next 5 words are unless the proviso. Just glance at it for a second, Malus. Just come to page 56 of my note, just to refresh your Lordship memory. My Lord has seen it. 56, small page 56 of my note. That suffix is ignored by my learned friend. My learned friend ignores the suffix. Does my Lord have page 56?
What suffix is ignored?
At least he's interested in my argument. Not agreeing, but interested.
The learned attorney forgot to mute it. So,
that's correct.
yeah, he was speaking to himself.
Saying what suffix is assisting advocate will show him
I'm sorry for the interventions.
Yes.
Page 56 is the suffix. My Lord sees the 4th line of page 56.
Yes.
The bill falls through unless the procedure indicated in the proviso is followed. If my Lord reads it like that, no problem. It fits in perfectly. What is the problem? You are creating a problem and then trying to solve it. Now, what my learned friend says is, falls through, full stop. Is the first option, he says. Next is returning, passing, consideration. Those are other options. But that's a very...
he wants to read that he may declare he withholds the assent therefore,
yes.
In which case the bill falls through.
That's it. What about...
Trying to use the words, unless the procedure indicated in the proviso is followed.
That's right.
So if the procedure, their argument as we understand.
Correct.
If the governor decides to declare it to be withheld, then it falls through, save and except where he decides to follow the proviso. In that case, it will not fall. So that appears to be their argument. So the argument that we understand is that there is an absolute power in the governor.
This is the argument with great respect. Their argument has only one merit. It's a simple argument. The word falls through, stops. That's the Lordship's first option. No sending back, no reconsideration, no repassing. She remembers that Kameshwar is not on this issue at all. It's a descriptive sentence which summarizes. Kameshwar issue, just give me 30 seconds more, Mulus, at page 55 is a different issue.
Whether a second time reservation is permissible or not.
No, it is in fact a different issue. Whether a bill is to be granted assent by the governor to become a law first and then
And
refer,
then send it to the president.
which is quite a bizarre with respect. It's quite a
Argument advanced that unless he grants assent,
you can't send it.
he can't
Your Lordship,
reserve it for the
the
president.
moment the Lordship grants assent becomes the law. Then what do you refer it to the president for? I'll come to the courts then. Then the courts step in. That was the issue. In the course of that, at page 56, I'm sorry.
Yes.
In the context of that, at page 56, describing it, they say, unless the procedure indicated in the proviso is followed. The short, simple answer is, at any stage when the proviso is being followed, it can fall through. The assembly may not reconsider, the assembly may not repass, it may not send it back to the governor. That is the meaning of unless the procedure indicated in the proviso is followed. It completely harmonizes, unless you want to create a dichotomy.
No, please repeat.
The meaning of falls through, when they used it in the descriptive sense in page 56 and 59, respectively in Kameshwar and Valuri, is simple. When the governor returns it, at any point the bill may fall through unless the procedure of the proviso is followed, which is the assembly may not reconsider it, it may not repass it, it may not resend it back to the governor. That is what it means. It does not mean that the governor is given by an unknown, unwritten letter the power to withhold assent simplicity by locking in the cupboard. That's 56. Same in Valuri, where also the issue didn't arise directly at all. At page 59, just see the same thing. It's completely ignored. The question in Valuri was Article 252. But leave that, come to 59. Just again, harmonize. In both cases, my learned friend stops at the first step. Come to 250, page 59 of my note. Number 2, he may, except in the case of a money bill, withhold his assent therefrom, in which case the bill falls through unless the procedure indicated in the first proviso is followed, i.e., return the bill to the assembly for reconsideration with a message. It's a descriptive sentence. The issue is not arising in the independent sense. Whereas your lordship returns the bill as a governor, it can still fall through. Falls through many times. Then, Malats, as I end on this, 2 more points. The crucial thing is to give a separate independent head of withholding assent and keeping it with himself. Remember, Malats, withholding assent means neither rejecting nor assenting, doing nothing. Will Malats overturn on its head the entire constitutional scheme? That's the most important argument. Your lordship is then making it a super legislature, a super CM, as far as the governor is concerned. It is contrary to the entire scheme of the constitution we are arguing for the last so many days. In effect, a withholding assent option is an option simply to keep it in limbo, indefinitely, no time period, permanently, semi-permanently. It kills the bill. The governor kills the bill. A killing of the bill is available only to the cabinet government, nobody else.
Legislature.
Which is cabinet form of government of which the legislature is the main part, but the cabinet is a subset of it. Cabinet is a subset of it. Correct? It can't be a power of killing a bill. The governor, your lordship will have no scheme of the act left, of the constitution left. And lastly, Malas, I'm just picking up on a sentence which fell from my Lord Justice Narasimha. It is not very vital to my argument, but it's just making a last point independently on this, which I end this. Malas, there is no other procedure known in the constitution of this falling through. The only thing known is this procedure in 200 and a separate procedure of lapse in 196. Unless a bill lapses, there is no falling through of a bill. There is no third, fourth, fifth category called falling through. Lapsing is 196. It's a separate defined procedure. It will lapse when it will dissolve. It will not lapse when it will dissolve. It will lapse when it will prorog, etc., etc. We're not concerned with that.
Falling through is an expression of a court, not an expression of
That's my case.
even interpret it on the basis
No,
of
I
either
am saying-
Banduri or
My learned friend's entire argument is based on those 4 lines. Well, that's my argument. Great respect.
taking two extremes.
Very well. Now, Malas, I leave that and come to just ending this part at page 61, just 2 lines. There is obviously no fifth option, which my learned friend, that's my para 39. Page 61, para 39. I have given 6-7 reasons for this falling through point. I've left it now, Malas. I'm on page 61, para 39. No fifth option. Obviously, I'm saying there's no fourth option also. Leave aside the fifth option. And the only option clearly given by the Constitution of Discretion, undoubtedly so, is the second provisory. I end on that, Malas, on this point. Malas, there is a small conclusion I put at page 61 to 62. Your Lordship will not, Malas, spend time reading it. It's the 2 swords in 1 scabbard argument I made orally.
You already made.
Ek myan mein do talwar issue. Leave that aside. I now turn to justiciability, where I'll try to save some time because it is mostly quotations. And well, I am dealing compositely with 4 issues: justiciability, judicial review. Your Lordship's doing judicial review means judicial supremacy.
Justiciability.
Well, questions are 3, 4, 6, and 9. Open the questions. 3, 4, 6, and 9. It starts at page 63 of my note.
3, 4.
3, 4, 6, and 9.
9.
Compositely, they are well, judicial review. My lords become supreme because my lord does judicial review, justiciability. All are these 4 issues. My lord can glance at the issues again. 3 is the exercise of 200 justiciable. 4 is also included. 361 is a bar to your lordship's judicial review. That's a question 4.
You have mentioned that.
Yes. So I'm just saying, Malas, these are the questions. Then, Malas, 6 is the exercise of 201 justiciable. Similar, overlapping. And then last and interestingly, 9 are the decision of the governor and the president under 200 and 201 justiciable at a stage anterior to the law coming into force. Is it permissible for the courts to undertake judicial adjudication over the contents of the bill in any manner before it becomes law? And in the submission, Mr. Mehta, he also used the word judicial supremacy, otherwise will be inaugurated, etc. So I'm dealing all compositely. As usual, Malas, I've made 6 or 7 point summary, then the quotations will come. So just read the summary, that's important. That summarizes the whole case in 2 pages. At page 63, para 47. This is the summary of the entire case on judicial review. Page 63, para 47. In respect of articles 200/201, neither the governor nor the president involved.
Para.
47, Malas,
47.
at page 63, small page. Big page is 542. May I read, Malas?
Yes.
Some of these are answering, Malas, Mr. Mehta's submission. Now, he used the word high prerogative. It's not my word. In respect of so-and-so, neither the governor nor the president enjoy any general high prerogative or plenary power which is immune from judicial review or justiciability. Why? In a constitutional republic governed by rule of law, judicial review and the supremacy of the constitution, not the judiciary, the very concept propounded by the government in this regard is fundamentally erroneous. This is expanded in paras 55 to 64. Judicial review has been repeatedly held to be part of the basic structure of the Constitution is exercised in diverse and multifarious situations, ouster clauses of different sizes and colors, no-go areas of different use, statutory and constitutional bars of differing width and amplitude have repeatedly been rejected by constitutional courts as a legitimate ouster of judicial review. Many diverse examples my lord has in every area. Where he has discretion, here in most cases he has no discretion, but where he has discretion, judicial review never ousted or even was in any manner controlled. Basic structure, that's 65 to 78. Actions in violation of explicit constitutional text or in breach of clear constitutional intent of the founders or at variance with the context of a constitutional provision or its rationale cannot be immunized from judicial review by recourse to the doctrine of political questions, which is wholly, my learned friend uses the phrase, this is not my word again, high prerogative and political question in Mr. Mehta's phrase, which I'm answering in para 79 to 85. Withholding of assent and thereby supposedly making the bill fall through has no connection with and is wholly unrelated to the alleged bar of quia timid actions wrongfully applied through the fallacious invocation of Quixote. One argument, learned friend, is that Quixote prevents quia timid injunctions. And a falling through means that your lordship will be interfering at the interim stage, and that is barred by Quixote. With greatest humility, it's the most convoluted argument. It has no application to the case, none. 51. Protective provisions providing an arc of protection for several diverse public servants, even in ordinary statutes, forget 361. And similarly to high personages like the President and the Governor in articles like 361, in respect of any act done or purporting to be done by them in the exercise of their powers and duties, have never been interpreted or applied to oust judicial review and justify arguments of lack of justiciability qua the actions and decisions of such persons. They are a well-established old paradigm for provision of a protective umbrella against personal, civil and criminal actions in respect of work done by holding their office. So, if I take a decision, your lordship quashes the decision right, left and center. But that doesn't mean that your lordship quashes, then I file a second action for tortious liability against the governor. 361 is that. And it's a well-known common law exception from 300 years in England, which has become 361. Judicial review, again, nothing to do with judicial review. Because judicial review hits the decision of the action. 361 bars the personal immunity from civil, tort, contract. It will be totally irrelevant to the case. I'll cite the cases coming in. The provision in US is on 361 is much narrower, but barring the last step has been interpreted by US Supreme Court to mean the US President can grant pardons to anyone, and now supposedly to himself also. Now supposedly to himself also. That last part is not decided, but it is likely that it is so going to be held. Anyway, let's go on. The fundamental fallacy of the Union of India's averments on the alleged non-justiciability of a governor's president's actions under 200-201 is that they proceed on the flawed assumption that the governor exercises high prerogative and plenary power. This is Mr. Mehta's submission in 281. Wrong. Completely decided cases say it is wrong. And then discretionary powers I've already said. Now let's go to 47. The first para was 47. I'm elaborating it from 55. Neither the governor nor the president enjoy any high prerogative or plenary power, immune. Well, this is found in para 55 of my note at page 281 of his submissions. Ignore it. Let's just note the reference. Ignore 56 also. Come to 57. Well, this is a slightly different but related topic I'm getting out of the way in the beginning. This is not that. Here I'm showing that governor exercises no legislative powers. It's well decided. He is part of a legislative process. He exercises no legislative powers. That's a very important distinction. The impression given to your lordship is because he's part of a legislative process, therefore he's also exercising some legislative powers.
The condition is not that, the condition is that he is also a part of the legislature. The legislature consists,
Malice,
no, that's their argument,
correct.
that in a bicameral house, the legislature consists of the two houses and the governor, and then unilateral,
Absolutely.
the legislative assembly and the
Malice,
governor.
to the extent that obviously Malice, when he receives a bill, gives an assent, before which it doesn't become an act, he's part of a legislative process. Therefore, the legislature consists of one house plus second house plus governor's assent. To that extent, I have no problem. But to add to that he exercises indirectly by virtue of the first point, any legislative function or power is constitutionally fallacious. That's what I'm showing. It's a nuance, very clear nuance. Navam Rebia decided it beyond doubt.
According to you, his powers are restricted by whatever is specified in 201.
200 and 201. That's the answer. So, Malas, you had to put 200 because there is one house.
Whatever options are available to him under 200.
Or 201 is the case.
Or 201.
He is the Malas mover of the bill. The mover of the bill comes to the assembly. One house. Goes to the upper house where it exists. Goes to the governor. No, nothing becomes law till the three steps are over. He's part of the legislature in that sense. That does not mean that he can either kill a bill. He can decide that the bill is a threat to national security, to foreign policy, to economic policy of India. That there is any extra power than what 200 gives. That's all I'm saying. Now, Navam Revia clarified this. Come to Navam Revia in para 57 of my submissions. Constitution bench, as your lordship knows. Well, there may be a typo there. That para is 147.2.
It's correct.
It's correct, I think, in your lordship's.
147.2.
Even though Article 168 postulates the legislature of a state would comprise of the governor, yet the governor is not assigned any legislative responsibility in any house of the state legislature. The only function vested with the governor is expressed through 200. This is what my Lord the Chief Justice observed just now, which inter alia provides that a bill passed by the state legislature is to be presented to the governor for his assent. And its ancillary provision, namely 201, wherein a bill passed by the state legislature and presented to the governor may be reserved by the governor for consideration by the president. The only exception to the non-participation of the governor in legislative functions is the ordinance making power. 213. The governor under 213 can promulgate ordinances during the period when the house is not in session. This function is exercised by the governor undisputedly on the aid and advice of the council with the chief minister as the head. Then Mark Justice Kehari uses this phrase again and again, Manus. All in all, it is apparent that the governor is not assigned any significant role even in the legislative functioning. Then 148. The above position leaves no room for doubt that the governor cannot be seen to have such powers and functions as would assign to him a dominating position over the state executive and the state legislature. This your lordship saw earlier. See the bottom of that page. According to the respondents, it makes the governor's orders based on his own discretion immune from judicial review. Same argument. Accepting the above position will convert the governor into an all-pervading super-constitutional authority, what I call a super CM or a super legislature. This position is not acceptable because an examination of the executive and legislative function of the governor from the surrounding provision of the Constitution clearly brings out that the governor has not been assigned any significant role either in the executive, which we are arguing, or the legislative functioning of the state. Then, Wallace, this is the question which came last time also. It's directly answered by me orally. Now I'm put in writing here, Wallace, in this para. That is para 58. In para 286 of its submissions, and I have serious objection to many of these paras because they turn the constitutional scheme on its head completely. 286, for example, says that the governor has decision-making functions and has to consider questions of repugnancy or violation of constitutional fundamental rights is ex facie erroneous. Stated briefly, the tests of constitutional vices, repugnancy, are to be tested by the judiciary under Articles 32 or 226 under judicial review. The governor does not possess any powers to conduct such an examination of the bills duly passed by the assembly, save and except as per the second alternative argument that he can either send the bill back or refer it to the president, that's a different matter. You can't judge it. You can't judge it. He cannot conduct a de facto judicial examination or adjudication and hold back assent indefinitely on his own perceived view about the alleged unconstitutionality of any bill. Then let us come to 66. The suggestion is,
66.
yes, 65 is a repetition, Navam Rebia is again the same thing. 66 now. Oh, I'm sorry. No, my apologies. Sorry. 60. My mistake. I read 59. 60. It is equally wrong to suggest that because the inaction of a governor or exercise of non-existent power under 200 would be subject to judicial review, even grant of assent by the governor, one argument made is that if you are doing judicial review of withholding and all this, then even the assent can be subject to judicial review. And that too by a private party. Specific argument in para 290 of the SG's submission. Now my answer to that. A private party can challenge a statute only on the constitutional varies of a statute or a lack of competence in its passage. The challenge would not be based on allegations requiring examination of the assent granted by the governor. But these are all created controversies with greatest respect. They are very well established for 75 years of our republic. In other words, any bill is challengeable by any such private party only when it becomes an act of parliament or state legislature. Because I come to your lordships many times before the act, your lordship says a bill, go back. Happens all the time. After this happens, the challenge is on the usual constitutional grounds, ranging from alleged lack of legislative competence to a whole range of constitutional invalidity, allegedly arising from diverse provisions like 14, 19, 21, 300A. These are what we do before my lords. None of this involves or can involve a challenge to the governor's or president's decision to grant assent. It has never happened. In none of such situations is it necessary or conceivable the private party will challenge or needs to challenge the factum of assent or why the governor president gave assent. This is a completely erroneous argument. Such issues are completely alien and irrelevant and have been erroneously conflated in the written submissions. Equally fallacious is the return to prerogative power. Prerogative power is mentioned in 280-81 of his submissions. This is again Malus conflating it with the royalty. Your lordship has said, in a republic like India, there is no such thing. We are a republic governed by the constitution. A republican constitutional system with a dynamic written constitution is antithetical to any concept of prerogative powers in any authority unless, in the rarest of rare cases, a specific constitutional provision consciously and specially chooses to invest that authority. That's not prerogative, that's constitutional power.
Like 356.
Like 356, exactly. And other matters. The decision of this, and Maras, the interesting thing I'm coming in this, 356 clearly gives you discretion. So does 362 and those Maras provisions of pardon. 200 is where you have no discretion. Even in 356.
You have a discretion, you can make choices between what option given under 200. Either to withhold or to give assent or to reserve it for the.
It's a constitutionally given option. Discretion within each option is not available. Now, in the articles where discretion is available, 356, 362, 372, 371, even there your lordship has done full judicial review. My learned friend is saying there is no judicial review where discretion is absent. In articles with wide discretionary zones, my lord has done vigorous, full, comprehensive judicial review. That's the story your lordship is coming to now in a minute. But first see this prerogative. This is only on the prerogative. The next question is whether this court should adopt the rule of construction accepted by the Privy Council. This is 67 judgment. There are many reasons why the said rule of construction is inconsistent and incongruous in the present setup. We have no crown. The archaic rule based on the prerogative and perfection of the crown has no relevance to a democratic republic. It is inconsistent with the rule of law based on the doctrine of equality. It introduces conflicts and discrimination. And my learned friend raises it directly in 280-81 of his submissions. Then come to the next page. Are you sure? Just check it. Yes, well, I forgot to write there. I'm told this is 9 judges. Just check it. It's my fault.
Which one?
This was superintendent.
Corporation of Calcutta.
9 judges. I should have written it there. Kindly write it there. That combination is rare now. Sign 367. 67. Now let's come to the next page. 24. Page 69, small page, para 24. There is therefore no justification for this court to accept the English canon of construction, for it brings about diverse results and conflicting decisions. On the other hand, the normal construction, namely the General Act, applies to citizens as well as state, unless it expressly or by necessary implication exempts the state from its operations, steers clear of all anomalies. It prima facie applies to all states and subjects, a construction consistent with the philosophy of equality. In our constitution, this natural approach avoids the archaic rule and moves with the modern trends. This will not cause any hardship to the state. The state can make an act if it chooses, providing for its exemption from its operation. Last sentence is important, Manas, because prerogative was used to exempt yourself. Now this statute will exempt it if you want to. Next page, 70. We therefore hold that the said canon of construction was not the law in force in the meaning of 372. In any event, having regard to the foregoing reasons, the said canon of construction should not be applied for construing statutes in India, namely Malas exemptions drawn from the prerogative power. That was the issue in that case. Followed Malas in Ravi Chandra. Tell me the number of judges, write it down.
This was by how many judges?
Yes.
Ravi Chandra was how many judges?
Division bench. Ravi Chandra is division bench. And it specifically follows Malas, this 9-judge bench. Just see the boldface. Governments, taking a cue from the English experience, initially asserted they are not subject to the law, insisting upon the continuation of the royal prerogative by virtue of Article 372, which enabled the Crown in the UK to assert its right to insist that it was not bound by the law unless there was express statutory intent. Mercifully, a later judgment overruled that understanding. Very pithily put, Malas. Then, Malas, they have quoted mercifully that judgment on the next page. I'll not read it, the same judgment. Come to the lower part, Malas, para 65. Now, in 65 onwards, I'm elaborating 42 and 52, where the proposition was judicial review has been repeatedly held to be part of the basic structure. Because these 4 issues are judicial review, your lordship has gone very far. While an friend is talking of non-discretionary power not being amenable to judicial review. I'm going to show lordship other extreme of reality. It is not in any manner, so it is part repeatedly of the basic structure. It is not in any manner synonymous with or intended to result in the supremacy of the judiciary. That's a very erroneous submission. Judicial review has been repeatedly held to be part of the basic structure in multifarious situations. And the best is, when the lordship has tried to oust or attenuate judicial review in different hues and colors, in different situations. My lords have had those experiences. And what have my lord said? 66. Judicial review is not in any manner synonymous with or intended to result in the supremacy. The judiciary, Malas, is the designated organ as the interpreter of the constitution. And the job is to ensure the supremacy of the constitution through judicial review. Your lordship is the designated organ. Your lordship can't help it. You have no option. If you are the designated organ to decide the supremacy, not of the judiciary, but of the constitution, then you are doing that job and not making the judiciary supremacy supreme. Now, Malas, this is the approach when a lordship tries to even attenuate judicial review. This judgment is 7 judges, para 68. My lord may not find that, because it was added later on by me. 7 judges. That is, Malas, powers, privileges, immunities of state legislatures at para 68. This is 7 judges. And Malas, Chief Justice Gajendra Gatkar says, the supremacy of the constitution is the correct phrase, not the supremacy of the judiciary. The fact that you are the interpreter does make you supreme. That's a different matter. This supremacy of the constitution is protected by the authority of an independent judicial body to act as an interpreter of a scheme of distribution of powers. Then, Malas, state of Rajasthan was a letter saying the state government should go. 7 judges in state of Rajasthan. And these are all examples where discretion is available. Discretion is given. And yet look at the judicial review. 150, page 73, larger page 552. But one thing is certain, that if the satisfaction is mala fide or is based on wholly extraneous and irrelevant grounds, the court would have jurisdiction to examine it, because in that case, there would be no satisfaction of the precedent in regard to the matter which is required to be satisfied. The satisfaction of the precedent is a condition precedent of the exercise of power under 356. Of course, by reason of clause 5, look at this for us. The satisfaction of the precedent is final and conclusive and cannot be assailed on any ground. But this immunity from attack cannot apply where the challenge is not that the satisfaction is improper or unjustified, but that there is no satisfaction at all. In such a case, it is not the satisfaction arrived by the precedent which is challenged, but the existence of the satisfaction itself. End of that page. Where it is possible, the existence of satisfaction has always been challenged on the ground, not bona fide alone, based on extraneous and irrelevant grounds. Enough techniques and tricks have been tried. Your Lordship has found enough language to get around it. Now see this Bomai. Now the first one is 9 judges, of course. First, this what I'm reading, para 96, is by Justice Sawant and Kuldeep Singh. Justice Kuldeep Singh. The Constitution is essentially a political document, and provisions such as 356 have a potentiality to unsettle and subvert the entire constitutional scheme. I'm just reading only the boldface. It's enough. Don't think that I'm avoiding anything. It's just that it's enough, I think. Democracy and federalism are the essential features of our Constitution and are part of its basic structure. Any interpretation that we place on 356 must therefore help to preserve and not subvert that fabric. Now, next page is important. Page 75. So long as the states are not mere administrative units, but in their own right constitutional potentiates with the same paraphernalia as the Union and with independent legislature and the executive constituted by the same process as the Union, whatever the bias in favor of the center, it cannot be argued that merely because, and assuming it is correct, this is the direct point for us, the Constitution is labeled unitary or quasi-federal or mixture of federal and unitary, the President has unrestricted power of issuing a proclamation under 356. Then this 255 para is by Justice Ramaswamy. Some of these things are missing in your submissions for us. Judicial review is a basic feature of the Constitution. This court, high courts have constitutional duty and responsibility to exercise judicial review as the sentinel on the qui-vive. Next page. However, justiciability of the decision taken by the President is one of exercise of the power by the court, hedged by self-imposed judicial restraint. It is a cardinal principle of our Constitution that no one, however lofty, can claim to be the sole judge of the power given under the Constitution. This court, as the final arbiter in interpreting the Constitution, declares what the law is. Higher judiciary has been assigned a delicate task to determine what powers the Constitution has conferred on each branch of the government, and whether the action of that branch transgress. It is the duty and responsibility of this court and the high courts to lay down the law. That's why Lordship is called supreme, and that is the supremacy of the Constitution you are upholding. It is a constitutional duty to uphold the constitutional values and to enforce the constitutional limitations. The judicial review therefore extends to examine the constitutionality of the proclamation issued under 356. And we are dealing fully with justiciability. When your Lordship finds that your Lordship is doing in the act of doing judicial review, some question I ask is not capable of, your Lordship, same phrase, really different species, judicially manageable standards, your Lordships cannot go into. Your Lordship takes your hands away. Justiciability is not a legal concept with a fixed content, nor is it susceptible of scientific verification. Its use is the result of many pressures of variegated reasons. Justiciability will be looked at from the point of view of common sense limitation. Judicial review may be avoided on questions of purely political nature. Though pure legal questions camouflaged by political questions are always justiciable, the courts must have judicially manageable standards to decide a particular controversy. The next 4 lines may also be underlined. I have not underlined it. Justiciability on a subjective satisfaction conferred in the widest terms to the political coordinate executive branch created by the constitutional scheme itself is one of the considerations to be kept in view in exercising judicial review. There is, of course, the initial presumption. Then, 372 is Justice Jeevan Reddy's author, Justice Agarwal with him. Justice.
So next line would also be relevant.
There is an initial presumption the acts have, I said so, initial presumption that the acts are regularly performed. Always. You start with the initial.
You start with the presumption.
You always start.
And then
you can't straight away say that this is on the face of the
person who challenges that.
Absolutely.
To rebut it.
There's no problem.
And unless there is a strong material, the court will always presume in favor of.
The challenger has to overcome the presumption. After he has broadly overcome it in the prima facie stage, it shifts to him. Your Lordship asks him the questions. It shifts back to me, in case I am not able to answer the question. Absolutely. Your Lordship does it every day. Now, my lord, this is Justice Jeevan Reddy and Justice Agarwal, starting from 372. Come to the next page, para 373. I've quoted more because I want to not suggest that I'm not quoting the entire thing. Para 373. Whenever a proclamation under 356 is questioned, the court will no doubt start with the presumption that it was validly issued, but it will not, this is my Lord Chief Justice's query just now, it should not hesitate to interfere if the invalidity or unconstitutionality of the proclamation is clearly made out. It should not hesitate to interfere. Refusal to interfere in such a case, very strong words, Manus, would amount to abdication of the duty cast upon the Supreme Court and the High Court by the Constitution. Then, Malus, the judges give Malus the grounds. They cite a lot of case law, Malus. And your Lordship knows otherwise. I have quoted 3 sets of judges, Malus, in Bombay. I've quoted 3 sets of different judges, Malus. There are many more paras. This is not intended to be exhaustive. It's a very long judgment, Malus. Now I come to, can't have this keep changing constantly. Then Malus 71 para. This is Malus judicially manageable standards. Now Malus, I'm asking myself a simple question, common sensical. My Lord finds page 80, small page 80. Small page 80, para 71. Now, Malus, your Lordship, I'm sorry. Malus, this is judicially manageable standards, one part of it. You forget, Malus, for a case for 30 seconds. Your Lordship, let us say, finds that the governor is wrong in exercising a withholding assent or indefinitely for 1400 days, 2000 days, keeping back a bill. Suppose your Lordship so finds. What is the unmanageable judicial standard? And this is what I ask myself. If my Lord does not give the full remedy till the last, then it's only a formality. It's only a superficial adjudication. What is so impossible of judicial management? Your Lordship manages much more in judicial management and judicial review, much more. Here you have the text of the Constitution to guide you. So judicial manageable, I am only answering because my learned friend raised it. I think it doesn't arise at all. I'm only answering because he raised it. AK call, Malus. Just come to the bottom of page 80. Since the task of interpreting the provision of the Constitution entrusted to judiciary, it is vested with the power to test the validity of an action of every authority functioning under the Constitution on the touchstone of the Constitution, in order to ensure that the authority exercising the power does not transgress the limitation by the Constitution on exercise of that power. This power of judicial review is therefore implicit in a written Constitution, unless expressly excluded by a provision of the Constitution. So it's the other way around. Unless expressly excluded by a provision of the Constitution, the power of judicial review is available.
No. Such exclusion is also held to be
Correct.
violating the basic
No,
structure of
my Lord attenuates it. For example, Manus, atomic energy plant. My Lord sometimes in a statute, it happens in a statute, attenuates it. That no natural justice is required, no hearing, because it's a atomic energy, some sensitive war plant. I mean, those are very rare cases in a war or in some military installation. Nobody is arguing that kind of case. You are arguing that this is, these are all answers to arguments. There are 4 arguments. Judicial review is minimal. It is not justiciable. There are no judicially manageable standards. It is a political question. It's a high prerogative power. All this is set for 200 and 201, Malus. What is the texture and the textual feel of 200, 201 if your Lordship has a thicket of these objections, one after the other? The only intention is don't go to the real issue. Justiciably relates to a particular field falling within the purview. So, Malus, your Lordship is right. In a particular judicial review, you have, but you will not do it in an atomic energy, national security, war situation. That's obvious. It's common sense, Malus. It's a common sense. And I don't think the courts have 99% messed up on that account. The courts are wise enough to know the field. We know the difference immediately, where your Lordship is a no-go area and where there is no problem. It's a self-imposed limitation. It's completely self-imposed. There are 1 or 2 aberrations, my Lord always finds. That doesn't make the rule, Malus. My Lord knows of the aberration of a platform in my Lord's home state in Allahabad. where a judicial
Don't
officer
cite individual cases, otherwise he is going to start from 1952.
on account of want of judicially manageable standards, there may be matters which are not susceptible to the judicial process. That's the Lordship's own, whereas what is known as nuancing. Then, whereas, I'm not reading it, para 72 of mine quotes mentions Rameshwar, which fully endorsed Bommai. That's another 5-judge bench, endorsing a 7-judge bench with those on that point. Now, there is a little overlap. I must read the next page of Rameshwar, which deals with personal immunity. But note that 361 is not this subject here. But Rameshwar comes here, it deals with 361, but I'm not dealing with 361 yet. It's coming later. But I'll read Rameshwar. It's important on judicial review. 361 is coming shortly, though Rameshwar here also deals with 361. We are unable to accept the contention urged by learned Attorney General, Solicitor General, Additional Solicitor General appearing for the government that the report of the governor itself is the material and that it is not permissible within the scope of judicial review to go into the material on which the report of the governor may be based, and the question whether the same was duly verified by the governor or not. This court cannot remain a silent spectator watching the subversion of the Constitution. It is remembered that this court is the sentinel on the qui vive. This is what the Bommai said. Next page. Page 83, para 173. A plain reading of the aforesaid article shows, after that, the boldface. They give an example in judicial review. The personal immunity from answerability provided in 361 does not bar the challenge that may be made to their actions. It's very simple. Under law, such actions, including those actions where the challenge may be based on the allegations of mala fide, are required to be defended by the Union of India or the state as the case may be. I'll come to that in a minute. Even in cases where personal mala fides are alleged and established, it would not be open to the governments to urge that the same cannot be satisfactorily answered because of the immunity granted. In such an eventuality, it is for the respondent defending the action to satisfy the court either on the basis of the material on record or even filing the affidavit of the person against whom such allegation is made. 361 does not bar filing of an affidavit if one wants to file on his own, and that's done in many cases. The bar is only against the power of the court to issue notice of making the president or the governor answerable. In view of the bar, the court cannot issue direction to the president filing, etc. Just pause here for one conceptual diversion for 30 seconds. In one sentence, it completely harmonizes. X, the president or the governor, takes a decision Y. Number one, the decision Y can be challenged on all available judicial review grounds. I don't have to recount them. Number two, that challenge includes a mala fide challenge to the decision. Number three, neither of these challenges by me to legislative competence, decision, vires 1914 allows me to personally sue the president or the governor. Give me damages because you made a wrong decision. Give me penal damages because you made a wrong decision. Number four, even in mala fides of that decision, the government of the day, the secretary, files an affidavit. It doesn't mean that because the governor is immunized from filing for his personal immunity, that mala fide decision will go unchecked, unsupervised. So what's the disharmony? The disharmony is what you deliberately have created because you want to avoid scrutiny. It's as simple as that. Now come to Epuru, next page, 84. Just the controlling factor in determining whether the exercise of prerogative power is subject to judicial review. Whether the exercise of prerogative power is subject to judicial review is not its source, but its subject matter. This is the point. Very well put, Balas. It can no longer be said that the prerogative power is ipso facto immune from judicial review. So source doesn't matter, the decision matters. Bottom of that same page, rule of law principle comprises government according to law. The ethos of government according to law requires the prerogative to be exercised in a manner which is consistent with the basic principle of fairness and certainty. Now, let's come to page 85, para 47. Clearly, your lordship has a discretion in the president and the governor for pardons. Nobody disputes that. 200, you have no such discretion except second proviso. But in pardons, look at the judicial review your lordship exercises. Whole scale. The power under 72 and 161, which is the respective powers, is of the widest amplitude and envisages myriad kinds and categories of cases with facts and situations. The exercise of power depends upon the facts and circumstances of each case, and the necessity or justification of exercise of that power has to be judged from case to case. Important to bear in mind that every aspect of exercise of power under 72, as also 161, does not fall in the judicial domain. In certain cases, a particular aspect may not be justiciable. However, even in such cases, there has to exist requisite material on the basis of which the power is exercised, as the case may be. In such circumstances, one cannot draw the guidelines. See the next parameters. Next para. As stated above, exercise or non-exercise of power of pardon by government is not immune from judicial review. Though the circumstances and the criteria to guide exercise of this power may be infinite, one principle is definite and admits of no doubt, namely that the impugned decision must indicate exercise of the power by application of manageable standards, and in such case, courts will not interfere in supervisory jurisdiction. By manageable standards, we mean standards expected in a functioning democracy. A pardon obtained by fraud or granted by mistake or granted for improper reasons would invite judicial review. I think I made an error not underlining that. Lordship may kindly underline that.
It is already emboldened.
It's in very well. The prerogative power is the flexible power, should be adjudged, etc. Then next page, Willis. In conclusion, it may be stated that there is a clear symmetry between the constitutional rationale for review of statutory and prerogative power. 4 lines later, the exercise of prerogative power cannot be placed in straitjacket formula regarding the extent and amplitude of power bound to vary. When the impugned decision does not indicate any data or manageable standard, decision amounts to derogation. Well, its prerogative was most used for pardon. Because when the pardon power came in 72 and 161, they said it goes back to the royal power to pardon, etc. So that is what is being debunked here. Then, of course, the be all and say, most famous was Keshwanand, just two paras. Justice Sharath and Grover, the Constitution being supreme, all the organs and bodies owe their existence to it. None can claim superiority over the other, and each of them has to function within the 4 corners of constitutional provisions. This I am doing on judicial supremacy. My Lord has become supreme. He has arrogated the power. It is excessive judicial. Those kind of arguments. You are implementing the supreme document. Next page. The Constitution has all the essential elements of federal structure, as was the case in the Government of India Act 35. The essence of federalism being the distribution of powers between the Federation of the Union and the states. All legislatures have plenary powers, but these are controlled by the basic concepts of the Constitution itself. Then I'll skip that, Balas. Just come to judicial supremacy at the bottom of page 88, para 577. This is direct on judicial supremacy. My learned friends, written submissions raises, Balas, I submit the red herring of judicial supremacy. We are unable to see how the power of judicial review makes the judiciary supreme in any sense of the word. This power is of paramount importance in a federal council. Well, when Keshwanand has said so, where else do we need to go, man? For judicial supremacy, well, this is the best answer. See the next page, 89. Judicial review is undertaken by the courts not out of any desire to tilt at legislative authority in a crusader spirit, but in discharge of a duty plainly laid upon them by the Constitution. I know judges' names. You are asking that. His names. Then, well, at the bottom of that page, there is ample evidence in the Constitution itself to indicate that it creates a system of checks and balances, by reason of which powers are so distributed that none of the 3 organs it sets up can become so predominant so as to disable the others from exercising and discharging powers. Though the Constitution does not lay down the principle of separation in all its rigidity, as is the case, yet it envisages such a separation. The judicial review expressly provided by means of 226 and 32 is one of the features upon which hinges the system of checks and balances. Next page answers the supremacy argument, page 90. The function of interpretation of a constitution being thus assigned to the judicial power of the state, the question whether the subject of law is within the ambit of one or more powers of the legislature conferred by the Constitution would always be a question of interpretation of the Constitution. Then, well, at page 91, Justice Jaganmohan Reddy was faced with the argument, political question, no judicial review, less judicial review. He answers it thus, page 91. There is no, in one sense, there is no constitutional matter which in some way or the other does not involve political, social or economic questions. Otherwise, the Lordship will not be dealing with the Constitution. Your Lordship will be dealing with some petty statute. And if the constitution makers have vested in this court a power of judicial review, and while so vesting, have given it a prominent place, describing it as the heart and soul of the constitution, we will not be deterred from discharging that duty merely because the validity or otherwise the legislature will affect the political or social policy underlying it. And then the next underlined portion are also important. I am not reading it. Minerva, which was the main judgment, was on the direct point after Queshwananda, page 92. Page 92. But then the question arises as to which authority must decide what are the limits of the power conferred upon each organ, and whether such limits are transgressed or exceeded. So who will do it? Your Lordship will do it. So your Lordship will have to face the charge of being supreme. We are the last word on interpretation. 93, Manas. 93. It is the solemn duty of the judiciary under the Constitution to keep the different organs, such as the executive and the legislative, within the limits of the power conferred. That's another job, Manas, which makes you supreme. You must keep them within the limits. The power of judicial review is conferred on the judiciary under 32 and 226. If I was asked to name, this is that famous Dr. Ambedkar lines, Manas. If I was asked to name any particular article in this constitution as the most important, an article without which this constitution would be a nullity, I could not refer to any article except this one. That's 32, Manas. It's the very soul of the constitution, very heart of it. I'm glad that the House has realized it's important. This is your Lordship's first entry into judicial review. This is your Lordship's first entry into judicial review. High Court's first entry is 226. Together you make up that judicial review, Manas, calculus. And I'll be dealing with my learned friends 32 argument, which took 1.5 hours, Manas, on the last day when I was to open in the morning. I'll deal with that very briefly.
Whether the state is entitled to.
Yes, yes. Actually, well, I'll show there, the issue is not referred to your Lordships at all. The issue is some other issue. Article 131 is the question the President asked. Article 32 is the question Mr. Mehta is asking. But that apart, I'll deal with why the state can't go. Mr. Mehta has reformulated his own additional question under that question. It's only a 131 question. And in 131, he concedes that the state suing, the state filing against the governor is not an interstate and is not central. He concedes that. And then formulates an additional issue that you can't file a 32, which the President never asked you. I am going to argue the Lordship will refuse to answer that question, but I'll otherwise satisfy my Lords. Next verse, page 93. 93. The judiciary is the interpreter of the Constitution. The judiciary is assigned the delicate task to determine what is the power conferred on each branch of government, whether it is limited, and if so, what are the limits and whether any action of that branch transgresses such limits. It is for the judiciary to uphold the constitutional values and to enforce the constitutional limitations. 94. The power of judicial review is an integral part of our constitutional system. Without it, there will be no government of laws, and the rule of law would become a teasing illusion and a promise of unreality. This is what I comment to your Lordships as we near the end of judicial review shortly. Then, Malas, para 77, page 95. Another argument raised was repeatedly destabilizes the constitutional balance. That's the third line of 77. Well, this is too general. The answer has to be general. My answer is the last 4 lines. If this argument is accepted, that the governor and president would be insulated from judicial review, which would expand the jurisdiction without any limits and is directly antithetical to separation of powers. Then, Malas, para 49 is the political questions, just one judgment, Malas. Just see the last line on page 95, political questions. It's totally irrelevant. It is raised in my learned friend's para 283 of the written submissions, which I mentioned in para 79 of my note. He raises it. And Malas, the answer is the same Keshwananda Bharati paragraph from Justice Jagmohan Reddy, which I've read already, so I'll save time by not reading it again. My Lord has got that at page 96 for us. Same para.
You are again
quoted the same.
already proved that.
So I'm not reading it because that arose in this is specifically a political question. I'm not reading it. Minerva Mills Willis is next para 82, where it emphasizes that judicial review is part of the basic structure. and then come to 98, which I have not read. Minerva will, after emphasizing judicial review as part of basic structure, come to 98. But merely because a question has a political complexion, that by itself is no ground why the court should shrink from performing its duty under the Constitution if it raises an issue of constitutional determination. This is the short answer in India. All these prerogative political don't arise in India. It's either judicially reviewable, maybe not justiciable in one case. Judicially reviewable, maybe no manageable standards, or judicially reviewable. The controversy before the court may be political in character, but so long as it involves a determination of a constitutional question, the court cannot decline to entertain it. So long as the question is whether an authority under the Constitution has acted within the limits of its power or exceeded it, it can certainly be decided by the court. Indeed, it would be its constitutional obligation to do so. I have said before, and I repeat it again, that the Constitution is suprema lex, the paramount law of the land, and there is no department or branch or government above or beyond it. This is Minerva Mills. Every organ of government, be it the
Yes.
Every organ of the government, be it the executive or the legislature or the judiciary, derives its authority from the Constitution, has to act within its limits. The court is the ultimate interpreter of the Constitution. When there is manifestly unauthorized exercise of power, it is the duty of the court to interfere. And then page 99, the court cannot shirk this responsibility, sworn the oath of allegiance to the Constitution. It's also accountable to the people of this country. My lord is not accountable through elections. My lord is not accountable through nominations in that sense. But my lord is accountable in a different way. That is frequently forgotten.
You always criticize that we are not answerable or accountable to anyone.
That's all right. That's your lordship knows the limits, knows parameters. Then was page 100. Separation of powers is there. I'll not read it. Now, Mullahs, this very peculiar, strange argument at 101, that, let me summarize the argument. Mere withholding simpliciter and therefore falling through is an interim stage. My lord has frowned upon Quixote quia timid actions. De facto, we are on this side doing a quia timid action barred by Quixote. That's the simple summary of page 101, para 86 onwards. Whereas even as I state it, I don't understand how it arises. How two unlinkables are linked by the government. Completely unlinkable. Let me give the answer from para 86. Sir, complete red herring, misleading and one is completely erroneous. Challenge to governor's inactions or actions or withholding of assent are not quia timid actions in the first place. He has alleged it in para 414 of his submissions. Simpliciter withholding of assent without following the procedure of the first proviso is not a mere interim action, but has serious and far-reaching consequences of final act decision, mark the word final act decision, of intentional inaction and indecision, not envisaged in 200. It's very important. Well, first of all, just pause for 30 seconds. How is your lordship's fellows holding back an assent, keeping in the cupboard a interim action? It kills the bill. It's a complete killing of the bill. And I can't do a so-called quia timid action because of a defection law of Quixote. Simpliciter withholding of assent is not equivalent to merely leaving the legislative process in media res. This media res is my learned friend's phrase, not mine. This media res I picked up from his submissions. Well, I've read 87. Now I'm in 88. I'm answering him. In 88, he has used the phrase media res. It is not leaving the legislative process in media res. Media res means in limbo. Such simplicity of withholding will amount to a veto of the bill, which was never envisaged by the assembly. I'm in 89. Such unfettered and unchecked power outside judicial review. Then, Malas, Quixote is only to be stated to be distinguished. Para 90, in very quickly, Malas. Completely irrelevant. Firstly, there is nothing temporary or transient or partial about withholding assent simpliciter. It can be permanent, indefinite. Secondly, it is not in any manner akin to a speaker acting as a tribunal under the anti-defection law, who is acting in the process of taking a final decision. And therefore, in that context, Kyoto held in para 110. Chalk and cheese, Malus, is my last line. Chalk and cheese. Then, Malus, 51 is the 361 argument. Before I read it, Malus, one sentence. 361 protects you from civil, criminal, and tortious action of a personal nature. It does not even touch upon the judicial review of the decision which you have taken, which is open to all challenges. For which decision, certain people, this is not only president and governor, so many people, Wallace, election commissioners, CAGs, everybody is given that protection that you may take a bona fide wrong decision, court will strike it down. But 361 will not come, Wallace, and a damages claim. Otherwise, every decision can also have a damages claim. That's all there is. How it is relevant at all to your lordship's argument of judicial review, I don't know, Wallace. Firstly, the bare text of 361 makes it clear that it is intended only as a protective shield against personal, civil, or criminal action. 92. Secondly, the second proviso to 361 itself makes it clear that the validity and legality of all decisions by such constitutional functionaries are liable to be assailed by agreed parties, and that 361 is in no manner intended to preclude the initiation of such legal and constitutional. Otherwise, by 361, you mean you can't challenge a decision of a governor or a president. Just see the proviso, 361. Just for 5 seconds, just see that. It's the second proviso in the first clause in 361. So they give the protection in the opening words and the proviso. Then the second proviso at 361. 361(1). Second proviso. Provided further that nothing in this clause shall be construed as restricting the right of any person to bring appropriate proceedings against the government of India or the government of a state. But I'm developing in more. This is just reading the text. Kindly go further. 93. My page 103, para 93. Constitutional challenges against wrongful actions by the governors or presidents has nothing to do with making them parties personally in proceedings instituted, which is admittedly barred under 361. Otherwise, every decision or writ has a governor's name in the decision, in the name of the governor. Your lordships would go, Malus. Their actions or inaction would be defended by the relevant government and state authorities. That is by no way inhibited by 361. 94 is the one-line, two-line summary. Judicial review merely tests the validity and legality of such actions, nothing to do with personal claims in contract, etc. I now come, Malus, to a very important part, the third set of submissions, which is on questions 5 and 7, which is the timelines regarding governor and president. That starts from 104. We have finished judicial review, judicial supremacy, 361, justiciable review.
Your time out.
Well, this will be, I said so, well, my timeline and this timeline all be.
You had, your chart shows 4.5 hours.
But
At 12 o'clock, you'll be finishing your 4.5 hours.
no, my 4.5, I think, finishes. Well,
The chart shows 4.5 hours. You started at 12 on the last day. 12 to 1, go to 4.
After your lordship,
3 hours and now
only one person per state.
4.5 hours.
Only one person per state will be within our time, Malus, and I'll. This is the.
No, we are only saying.
We have worked it out. We are not.
Time of the other Tamil Nadu council.
Your second time of Mr. Wilson and all others.
That your lordship is barred already, Malus. Your lordship is barred, Malus. Hamlet, without which the Prince of Denmark is being played, Malus. Lordship, Malus, we'll work it out. I said, lordship, rest assured. Now, Malus, 5 and 7 is the one word is some timelines. Let me read the summary, which are the same. Page 104.
Small page, okay. Otherwise, private.
Small page 104. Now, let me summarize my submission at the beginning as usual, and then I'll expand. Deletion of a timeline in an earlier draft article and substitution of as soon as possible in the assembly is in no way a fetter or limitation on insertion of time limits to combat contemporary realities and the felt necessities of the time. This is a very important phrase, Varus, which imbues your lordship's approach, felt necessities and contemporary realities. Such deletion does not in any manner act as an inhibition or estoppel in respect of judicial stipulation of timelines in the context of repetitively and inordinately delayed disposal of bills by constitutional authorities. This is 102 to 4 is the first one. This also is covered in the same paras. As soon as possible could well have been held in the formative years to be sufficient mainly on the basis that bills pending with constitutional authorities would not lapse upon dissolution of parliament, of assemblies of parliament. Comprehensive Supreme Court jurisprudence has emphatically and repeatedly emphasized in diverse cases the imperative urgency in disposal of pending bills and the vital necessity to avoid all delay. These have become only, with greatest respect and humility, sermons without a timeline being specified. They have become this repetitive, emphatic assertion by different judgments of your lordships have become pious hopes, unless your lordship stipulates a timeline. High-powered commissions dealing with the same constitutional issues have repeatedly recommended time limits. That's 109 to 110. Then, there is a gap of something which I'll tell Lordship when I come to it. Purposive and theological interpretation. Now, this is a very important part of 8 to interpret. Purposive interpretation, what your Lordship calls teleological interpretation. Purposive and, this is wrongly typed, I'm very sorry, not theological, it should be teleological. Anything your Lordship may do, but not do theological interpretation. That phrase came from Benion's very interesting book. Made it very, very difficult to read, but one is an interesting book on interpretation. Kindly correct that, teleological is not only permissible, but vitally necessary to effectuate the true letter and spirit. That's what your lordship does when you do teleological, where the absence of such an approach would frustrate the entire underlying purpose. Seventh proposition. The judiciary can impregnate the constitution with new meanings, including timelines, in the light of contemporary well-known developments, even if the founding fathers had not envisaged the serious distortion to which a particular provision would be subjected. And last, you can't have completely always a right, a pious hope, and no remedy. So I put it as ibius, ibi remedium. To justify its stand that timeline should not be set under 200 and 201, it is firstly the argument of Union of India that the powers on the said articles are high plenary constitutional functions, and therefore no timelines can be attached. This is one argument, high plenary. I have already dealt with it, about high plenary and prerogative. Secondly, I'm just summarizing his points, in para so-and-so which I have given there of the learned solicitor, he argues that the 200 requires the governor to apply his mind independently, quote unquote, in deciding whether or not to assent to a bill. Union of India has submitted that in doing so, the governor has to consider, this is the reason why he needs time, indefinite time, no time limit. It's amazing, with great respect. And Union of India should think of the overall structure of the constitution in the future. Governor has to consider international aspects, security concern, and the political judgment. Then he should fight an election and become the chief minister. This argument of Union of India.
Why can't he consider international aspects, security concerns?
No. He can, consider it within the domain of sending it back once. That he can. He can neither withhold assent, nor kill a bill, nor decide not to do it. And ultimately, most important, as per the question asked, he can't be the judge of this. That is why this structure is a very delicate one, clearly stated in 200. Well, had it been that he can't at all think, they would not have given that first proviso. They gave that escape valve. But that doesn't make him a decider, a judger, a final arbiter, a super chief minister, everything. And ultimately, we are passing unconstitutional bills every day. Supposedly unconstitutional, allegedly unconstitutional. One party thinks is wrong, one party thinks. Whereas in Parliament, there's a debate always that when you're introducing the bill, you can't introduce it because lack of competence. At the introduction stage, there's a fights all the time. At the end of the day, if he's a majority, he introduces it. Then what happens? Your lordship judges it. That's the meaning of separation of powers. Now, let us come this as soon as possible. There's very interesting material in the debates also, but first let's turn to as soon as possible in para 100. Punjab is a perfectly valid judgment, well considered, and considers this issue directly, to a large extent. The interpreted this phrase as an imposition of a constitutional mandate for expedition. Imposition of a constitutional mandate for expedition. Come to the para quoted, these three learned judges. The expression as soon as possible is significant. It conveys a constitutional imperative of expedition. Failure to take a call and keeping a bill duly passed for indeterminate periods is a course of action inconsistent with that expression. Constitutional language is not surplusage. In state of Telangana, this court said, the expression as soon as possible has significant constitutional content and must be borne in mind by constitutional authorities. All these are empty phrases, pious hopes, sermons to be ignored endlessly. The Constitution evidently contains this provision bearing in mind the importance which has been attached to the power of legislation which squarely lies in the domain. Governor cannot be at liberty to keep the bills pending indefinitely without any action whatsoever. You're almost there. The only thing they did not say the time limit. But when you find repetitive inaction, you put a time limit. That's all that happened. Otherwise, he's saying everything about a time limit. Then next with Telangana, 2024. The first proviso to 200 says that the governor may, as soon as possible after the presentation, return the bill, if it is not a money bill, together with a message for reconsideration, right? The expression as soon as possible has significant constitutional content and must be borne in mind by constitutional authorities. Now, let's just see the Constituent Assembly. It's interesting. Article 91 in 111 mandated a timeline of 6 weeks. An oversimplistic argument is raised that because the lordship deleted 6 weeks, therefore you can't have a timeline. Just see how wrong it is. The argument is that your lordship original article had 6 weeks, they dropped 6 weeks, therefore you can't have a timeline. Let's see that. Para 102. Provided that the president may not later than 6 weeks after the presentation to him for a bill of assent, return the bill. 103. The phrase not later than 6 weeks was substituted with as soon as possible. No doubt. Now, Mr. Ahmed had a very interesting objection because he felt that as soon as possible also signifies immediacy. It's too short. His argument was make it longer or give it more time. It's too short. He says they did not leave any breathing time with the governor. Yes, sir, I beg to move in amendment so-and-so. For the words possible, the word may be substituted. Read the boldface. If we leave it exactly as Dr. Ambedkar would have, it leaves no margin. As soon as possible means immediately. This was the meaning they understood in the assembly.
One of the members.
Yes. No. This is not. This is accepted by the assembly because as soon as possible is kept back on this reasoning. My lord is right. His understanding.
Yes.
His understanding.
Of one of the members.
Oh, yeah.
Then one of the members recommended that it should be as soon as possible, but not later than 6 weeks. One of the members also said that it should be as soon as possible, but not later than 6 weeks.
So one was 6 weeks. Now this is a later stage. Give me a minute. 6 weeks was dropped and the draft which came before Mr. Ahmed had as soon as possible. We are beyond that stage now. Mr. Ahmed is standing on a draft of as soon as possible. Now he stands up and says, as soon as possible is also too fast. 6 weeks is gone. My lord is right. As soon as possible is also too fast, too immediate, he says, exactly. Make it little more, play in the joints, margin, he says, for the governor. Accepting that as soon as possible means an immediacy, Dr. Ambedkar and all his supporters retain that. That's the sequence I'm giving. So just read Mr. Ahmed again. As soon as possible means immediately. Possibility, which means physical possibility, is the only test. It may leave no breathing time to the president. The words maybe give him a reasonable latitude. It would mean reasonably practicable. This is the obvious implication. This is the only reason why I have suggested amendment. Now, after this, just for the Honorable Chief Justice's query, there is no real discussion in the CAD except minor things which are not relevant here.
No, there is one of the members suggested
Yes.
that you have the word as soon as possible.
And not later.
But not later than 6.
That was earlier. That was the earlier one. My lord is right.
But during the same course.
Yes, the draft came with 6 weeks. The draft came with 6 weeks. When they dropped it to as soon as possible, then this debate of Mr. Ahmed took place. Sequence is, my lord is absolutely right. Original draft had 6 weeks. They then said as soon as possible. Mr. Ahmed says, no, this is also too fast. They retain and stick to it without further discussion, is what I'm saying. Mr. Ahmed canvassed for a reasonable timeline, which was not immediate. He nowhere supported an indefinite time period, as is the stand. This is another second point. He nowhere supported another indefinite time period, as the Union of India argues. Mr. Ahmed was only concerned to the extent that he wanted to loosen what he thought was a very strict time limit as soon as possible, which he, Mr. Ahmed, read to connote immediacy. Then
There is
skip.
no number.
I beg your
Nazirul Ahmad used to oppose each and every proposal of Dr. Ambedkar.
lot of. Almost, your lordship is right. Whenever he got a chance to speak, he got
Huh?
Mr. Kamath too.
Become.
Then let's skip the rest of the paras, come to 108. Now, lordship, we come to 108. At page 110, para 108. That middle quotation, etc., lordship may skip. It's not so. Furthermore, this court has held that where no timeline is fixed, the powers have to be exercised within a reasonable time period. I'll be coming to your lordship's doctrine of unoccupied. In fact, the dropping of 6 weeks is the reason why your lordships can operate through judgments in the unoccupied field. Once there is a timeline in the statute, you cannot stipulate judicially. Judiciary can act in the unoccupied interstices where felt necessities require. So the absence of a timeline is what enables your lordships to add that timeline. Now come to Ramchand, 108.1. This is one of the proposition that you must exercise a reasonable time. But can it be said that before the introduction of the aforesaid amendment in the Act, the authorities were at liberty to proceed with the acquisition proceedings, irrespective of any schedule or time frame, and to complete the same as and when they desired? It is settled that in a statute where the exercise of power, no time limit is fixed, it has to be exercised within a time can be held to be reasonable. Now let us come to 11. Ignore para 108, doesn't matter. Come to para 109. Look at all the commissions, fellas. Consistently, one line. The necessity to impose a specific timeline was also identified and suggested by the Sarkaria Commission, which in its report says within 1 month from the date. A recommendation is made by the Punchi Committee, maximum of 6 months after the bill is presented. Then comes, your lordships, in 110, the National Commission, which is so-called Venkatachalaya Commission. This is the Venkatachalaya Commission. They say, period of 4 months, about they divide it, assent. Then other things are said, delete the words, withhold assent, etc., etc. Just see F, what they say. F is very interesting. The Venkatachalaya Commission, of course, it's a historical fact. In the alternative, the Venkatachalaya Commission, not me, it may be more advisable to delete altogether the words of Article 200 empowering the governor to reserve a bill for the consideration of President, except in the case contemplated by the second proviso to 200 and the cases where the Constitution requires him to do so. Such a course would not only strengthen the federal principle, but would also do away with the anomalous situation wherein a bill passed by the state legislature can be killed by the Union Council of Ministers, advising the president to withhold his assent or just cold storage. He goes very far. This is a facet I'm giving us. Now let's come to 113. So 3 commissions I've given them. In order to, I'm on para 113. In order to interpret as soon as possible, the union seeks to place reliance on a selective extract from Abdullah Kuni, which refers to Francis Coralie Mullin. Well, I am now quoting the relevant part of another paragraph of this judgment, which is, I believe, Malas, a constitution bench. This KM Abdullah is a constitution bench, CB. Some of these things should have been written by us. We have not written it there. It's a constitution
The
bench.
executive powers, Dr. Singh, not a constitutional. Basically, administrative law principle, not constitutional law principle.
No, I'm saying it's a constitution bench. I'm only saying it's a constitution bench, Malas. I'm not disputing as soon as possible will be my lordship's interpretation.
Administrative.
Yes. Well, sometimes those two are intertwined very, very broadly.
Sometimes.
Frequently, the magnum opuses on that topic deal with both worlds.
The larger
Constitutional and administrative law.
consideration.
But they can be separated, no problem. Article 5 of 22 therefore casts a legal obligation on the government to consider the representation as early as possible. It's a constitutional mandate commanding the concerned authority to whom the detainee submits his representation to consider the representation and dispose of as expeditiously as possible. The words "as soon as may be" occurring in 22(5) reflects the concern. I'm only giving analogies, Malas. Analogies. Reflects the concern of the framers that the representation should be expeditiously considered and disposed of with a sense of urgency without an avoidable delay. However, there can be no hard and fast rule depending on the facts. Now, Malas, this is cited against me, this judgment. This is cited against me. See the next boldface. The requirement, however, is that there should not be supine indifference, slackless or callous attitude in considering. Any unexplained delay in the disposal of representative with a breach of constitutional imperative would render the continued detention impermissible, illegal. Now, Malus, Kesham, my lord is aware of.
On a preventive detention.
I agree with you. Because they were interpreting as soon as possible, so I've just given that citation. Then Malus 117 is Manipur. I think your lordship is well aware of that. That is also a case where there is no timeline in the 10th schedule. The speaker is a high constitutional authority. He is not, of course, he is not Malus acting as a governor is. I know that. He is a persona designata. High constitutional authority.
No, but there he is acting as a
tribunal. As a tribunal. Correct, correct. But no time is specified. So your lordship specified 3 months. I'm only on that. I mean, it's not that, Malus, where the felt necessities.
3 months in the facts of the said case.
I beg your pardon? Yes, yes. That your lordship will decide. It's not that clear. I'm saying, Malus, that in fact, where there is nothing occupying the field directly, and your lordship finds contemporary realities and felt necessities so require, then it is all the more easier and frequently done by your lordship. There is no constitutional bar to doing this. That's all I'm saying.
That's what I have observed in that Telangana matter.
That's just coming.
That,
Absolutely.
it was thought to be argued by you.
Your lordship
That
is
in
to remind
Kyoto and the Navam, no period is prescribed. And therefore, this court is powerless to
so that
prescribe any period.
take out the relevant parts of that.
So answering,
Direct theory, there is the unoccupied field theory.
answering your argument,
Correct, correct.
I observed that
I am relying heavily.
in Kyoto and
Which your lordship, I'm relying heavily on the argument opposite to me, which your lordship accepted and rejected my argument.
we have.
I am entitled to this.
The authors of the Constitution bench would not have at that time imagined that the speakers would
Exactly.
sit endlessly and
That is what is meant by contemporary realities and the felt necessities of the time. Malas, otherwise, what is all this that a constitution is an organic document? It's an evolving document. It is an evolutionary trajectory which changes with the times. All these are mere phrases. unless your lordship transforms them into action in reality, because your lordship finds it across the country. I'm not saying anything well, it's political. I'm saying this is the reality. That is the real point. If your lordship finds, that's why I've given that, my lord notes the proposition at the beginning. Just because the fathers never envisaged a distortion, doesn't mean the lordships can't check that distortion today. Take it up, take it up. 5.48. My lord just noticed it can be done right on the side. Your lordship judgment is Telangana judgment, please. It's right here. 5.48. It's in volume 5.43. You should just note the citation on the side. Since you're also dealing with Manipur.
No, Manipur is Kesham.
Yeah. No, I'm saying Telangana. Lordship note on the side. I have not put it there. So it may help your lordship. Citation is the citation here. Very well. Doesn't that need the citation?
Because you know.
Volume is 5, the V.43. V.43. And the relevant page is this page. 17251, para 99. That is, Wallace, your lordships must act unless you are prohibited from acting. Otherwise, my lord is not doing justice in the felt necessity of the time. Citation in lordship knows, Wallace, 2025 SCC online SC 1576 is there on that volume 41. Now, Wallace, I have quoted Quixote. So I'm. Whereas just see Anup Baranwal, which I have quoted in 117. Give me that book.
Separately, 5.48.
It's not there?
It's on volume 5.48.
It's not here? Oh, I see. Well, it's
With
one
that,
right in hand.
in Allahabad case, court itself held that they were entitled to be disqualified. And the Supreme Court disqualified them.
That's coming, exactly. I've quoted that paragraph.
Yes.
Your lordships were felt that you've gone up the ladder, come up here. Now I send it back to the speaker. Now again the speaker starts. He says there is nothing which is prohibiting me. So we do it here. My lord gave the declaration and a mandamus here.
2 months.
If your lordships do not,
The tenure of the assembly were 2 months left. Therefore, court said
that's
sending
all right.
it
What
back
they did for not the
will
point.
serve no meaning.
The court held that
It's the power
the
which you
very
exercise.
fact that the
Yeah.
persons who were elected from Bahujan Samaj Party
Citation नहीं निकालते page.
addressing a letter that
Open the first page.
Mr. Mulayam Singh should be appointed as a governor itself amounted to.
Voluntarily giving up the membership of original political party.
Right on here.
In Kesham also, it was thought to be argued that this should be followed in Kesham also. Court rejected that.
That is this UP judgment, Allahabad judgment is Rajendra Singh Rana.
This court is coming here.
It was confirmed in, I think, Jagjit Singh. Jagjit Singh is confirmed in Rajendra Singh Rana.
Rana's constitutional bench doesn't require confirmation, so it's confirming the other judges.
No. The 3-judge bench was confirmed in constitution.
Now, there's one little thing which is missed out. Lords may add in hand. My lord may write 117A para, 2 lines. It's not there. 117A
is here.
Anup Baranwal is there.
It's here. So this Anup Baranwal is in 5.48 volume. That is not there. At page 18853, just write that. There is a passage there in para 291 and 301, which I wanted to read.
Para, the page.
Well, it's volume V.48. That is V is 5. V is now.
3.4A.
Page 18853. Just don't touch it.
1A.
18853. At para 291 is that page. And 301. Two paras.
291 and 301.
Correct. This is that general theory of unoccupied field. If my lords will just turn to that 291, if all my lords have got it, Justice Narasimha and Justice Suryakant don't have. Kindly give it. Just 2 small portions I'll read. Justice Suryakant has got it? 291. Lower part, at D, just above D. While it is true that ordinarily the court cannot without anything more usurp at
No,
classical,
at page 291.
no, para 291 was.
In fact, we
Para
may-
291, in fact, we may.
That's correct. Now at placitum D in that para, D for Delhi.
While it is true that,
While it is true that ordinarily the court cannot without anything more usurp what is purely a legislative power or function, in the context of the Constitution, which clothes the citizens with fundamental rights and provides for constitutional goals to be achieved, an inertia of the legislative department producing a clear situation, here there is inertia of not legislative department, some other department, where there exist veritable gaps or a vacuum, the court may not shy away from what essentially would be part of its judicial function. How many judges answer? Say that. No, check it first. This is also, Malas, a constitution bench. Kindly note that on the side.
no,
Varan.
Barawal is a constitution bench.
CEC.
Malas, it's not 301. My apologies, Justice Vikram Nath noted out. It's 309. The second para is 309.
291 and 309.
Yes. In the unique nature of the provision, don't ask after making me read it. It's able to do it quickly.
The Anu Barawal, I think, must be with regard to the appointment of the election commission.
CEC, election, chief election.
Huh?
In the
Chief
unique,
election commissioner. The article provided that till the law is made, this is the position. That was the.
that's the unoccupied field. That's unoccupied field. Till you make, suppose you make a constitutional provision that there shall, the governor may not decide.
Sorry, there the constitutional provision provided that till the law is made by the parliament, this would be the position.
It was not so simple as that. It was opposed tooth and nail, saying that you cannot provide for a system of election or selection of the commissioners. The court said that since there is an unoccupied field where no law exists as to how you will appoint, we can prescribe that. They did much more than a timeline. Much more than a timeline. Today, Mother, suppose my Lord gives a timeline. Let me answer my learned friend in 30 seconds. Suppose the Lordship gives a timeline of 1 month. Tomorrow the government enacts, there shall be minimum of 6 months. Obviously, Lordship timeline will go. They'll amend the constitution. That's all that constitutional bench did. There was no provision saying that you can do this or that. The provision was silent. This is a judgment on silence, which also takes care of the other argument on constitutional silences and abeyances. It is true that silences are pregnant with meaning. They are sometimes most eloquent. But equally it is true that silences allow your lordships to operate in the unoccupied interstices where public interest so desires. It's the second point which I'm emphasizing here. Here, Malas, the Constitution bench created a whole system of selection of the CEC only because of constitutional silence. And I've read 291 directly on point. It is to further the object. Obviously, Malas, it goes without saying that your lordship makes a timeline and my learned friend passes a constitutional law 1 month later. Obviously, it will go. Now 309. 309. In the para number, Malas. In the unique nature of the provision, we are concerned with the devastating effect of continuing to leave appointments in the sole hands of the executive on fundamental values as also fundamental rights. Is this not public interest for us? And much more nebulous than our case. Our case is directly, objectively verifiable cases of 1500 days, 1200 days, 1000 days. We are of the considered view that the time is ripe for the court to lay down norms. In other words, the vacuum exists, mark the word vacuum exists, on the basis that unlike other appointments, it was intended all throughout that appointment exclusively by the executive was to be a mere transient or stopgap arrangement, and it was to be replaced by a law made by Parliament, taking away the exclusive power of the executive. In our case, it's as soon as possible. In our case, you have a clear as soon as possible in the Constitution itself. This conclusion is clear and inevitable, and the absence of law even after 7 decades points to the vacuum. Constitution bench. Then, Malas, I will skip this Quixote. And come to Malas. Para 122
Of the notes.
of my note. This is Anup Baranwal Lordship put at 117A, which is already there, but these details are not there. Details are not there, that may be written by hand or something. Well, 122 is just to dispel a completely inapposite example given by the other side. No timelines can be given is a principle for adjudicating criminal cases, because valuable rights of appeal are taken away. That's P. Ramchandra Rao.
7 judges.
They said 7 judges. P. Ramchandra Rao is 7 judges in para 122. They frowned upon laying down time limits for criminal adjudication because the rights of the accused could be infringed. So they laid down the principle in 7 judges in that. That's a totally inapposite example to deal with me. Now, 123. I am fully aware, that your Lordship is not hearing any appeal from the division bench of Tamil Nadu judgment. We are all aware of that. I am reading a few paras to just try and illumine the reasoning. From 123. Come to page 118, para 19. The position of law is settled that even though where no time limit is prescribed for the exercise of any power under a statute, it should be exercised within a reasonable time. That is the principle. Now, Milits, please delete 124 and 125, including the chart. This is important, Millis. Your Lordship will be deleting pages 118 to 121.
Delete.
Just delete, Millis. From para 124 to para 125, which spreads across pages 118 to 1.
Because otherwise, you will get a.
No, I'm not yet. I'm not conceding or to his objection. I'm doing a different thing. Now, these pages are deleted. Lordship will just note one thing. I am not interested in the facts of any case. I am not arguing. Your facts would be relevant if your Lordship decided that this delay in this state is unconstitutional. I have a chart here of Tamil Nadu and Kerala only, which gives bullets all the bills which are bullets in more than 30 days, 90% of which you have to ignore.
The solicitor has said that if you rely on this,
And we have charts for
then
other
you will
states.
get so many charts from 1950. So let us restrict ourselves.
So,
to the
suppose I was
If
to
you
say,
want to travel
suppose-
that dirty
suppose-
path, I have no difficulty. I am ready to travel that path
No,
as well.
don't
But
just-
it's not necessary.
Because,
It's a presidential
Mr.
reference.
Mr. Mehta, threats don't work. Allow me to make my submission.
It's not a threat,
Come to
it's a
travel some dirty
objection
path,
to
you can
your-
do it. You can choose your own path. Allow me to finish. Suppose there are states other than Tamil Nadu and Kerala, which he has, he must be having, where there's the same delay.
No, I have details from 1947.
Must be having.
When the constitution was taken on a joyride.
Let him not interrupt me. He's eating to
And
me.
I often,
Interrupt me.
solicitor in 1947, 201 was not there, 200, 201.
He may have.
From not the inception of the constitution.
We will have to rely on 1935 provisions.
No,
Government of India Act 1935.
2000.
So if you are relying on any delays between 47 to 50, you will have to
The
rely on.
lordships have understood my reference to
Yeah.
1947.
Not on 200 and 201, because.
No, dear lordships have understood and they have understood my reference to 1947.
Of course, sir.
But from the date the constitution came into force, how, my lord, the constitution was
Allow
treated
me.
and
We
with
are
contempt.
not going to go into that.
Nobody-
Kindly, my lord,
allow-
then don't even take-
I have not made my submission. He's preempting me. His Lordship is not even allowed, he's not allowing to make the submission. What nuance I'm
Not
making.
based on these facts, my lord, then your lordships may not even take this on record.
Now,
But that's why.
we all
respect
understand that you are,
objection.
we all understand that you are threatening to show that all ills of governance are traceable to 1947. You need not say that. We are not on that.
To simply restrict yourself to the legal argument. Let us not go into the facts. of
Allows
it.
me to formulate it. The moment I mention some fact, he
We
gets
have
up.
been time and again, we don't want it to be,
Well, the moment I mention,
we don't want this to be converted into a platform for your political whatever.
so
it
let
is.
me make my submission.
I have not heard a word except law.
Can we also have some
Yes.
audience? If both of you permit.
No.
So let me, Bharat, not go to any facts. Let me make my proposition.
Yourself on the legal submission.
The proposition I'm making
With the proposition,
is only illustrative. Suppose, no, I'm just give it 30 seconds only. I'll not labor the point. I'm sorry. Assume that I am giving your lordship illustratively 10 examples. Assume he has 50 examples. Two wrongs don't make a right. The legal principle will be the same.
just make a proposition
Yes.
that you
Very
can
well.
say that the endless withholding is
Right.
not permissible
Let
in
me
law.
speak
So and
well.
so. Why should we go to the facts?
No, the lordship not going to the fact.
Otherwise, we'll be adding what happened. We'll have to listen what happened
Very
in
well.
77 and 75 and all that.
I-
Why do you want to? We don't want this to be converted into your political.
I had some interesting
Again,
facts, my lord.
interrupting my time,
Therefore, my
it's
lord,
not fair.
I had those interesting facts also.
Yes.
Our decision is not data-based.
Yes. Our decision is on questions of law, interpreting the constitution.
Why I am saying this is that your lordship's interpretation of the constitution depends on contemporary realities and felt necessity of the time is a test by your lordships. It's a test of purposive interpretation. Now, what that I did was, he interrupted me 3 times when I mentioned the word chart, fellas. I'm not giving it even to your lordships. I have a chart here which has these 4 propositions. Illustratively, I assume that it is true of West Bengal. I assume it is true of all other states. Two wrongs will not make a right for lordship adjudication. That's the point he's missing out. He said, I go show another chart. Let him show another chart. He'll support my proposition. He'll be supporting my proposition. The proposition,
Justify why this is
Mehta,
withheld.
We are not going to decide the matter on the basis of which political dispensation
No,
is in power or was in
on the
power.
law, I'm saying,
We are going to decide.
I am
on
asking
the
myself a
interpretation of
question.
the Constitution.
I am asking myself a question. The contemporary realities, purposive interpretation, teleological interpretation, and felt necessity of the time. Can your lordships ignore that in the sole case of Tamil Nadu, which actually occurred in this court, has in this chart 57 bills, the maximum delay in 1 or 2 is 1257 days. 3 bills from 500 to 1000 days. No, 3 bills more than 1000. 6 bills, 500 to 1000. That's all I'm saying. This matter came to the other court, brothers. It's not some foreign material.
Approximately, this which you are relying upon,
Yes.
it also contains the bills which were passed just recently in April 2025 also, right?
I'm not counting the 30 days bills. Your lordship is right.
Box is open, then we may be required to have in the list of those bills, hundreds of bills that might have been accepted also.
I am
And the
very well.
reason-
Very well.
and the reasons.
1 second, sir.
And the reasons for
Yes.
withholding.
So, let's
reasons
leave
for
this. Let's leave this because my time is
Sending
precious.
it back,
My
etc.
time is precious. I am not.
We need to parallel proceeding to examine what kind of amendments
No, well,
you are proposing to enact.
90% of bills in
With
this,
the
Mr.
governor.
Mehta, 90% of these bills I'm not touching upon. I'm mentioning 3 facts. 1 bill is 1257, 3 bills are more than 1000, and 6 bills are 500 to 1000. That's it, full stop.
So eventually, let us consider only the point of as soon as possible.
And
Your interpretation is.
purposive
that
and felt
as soon as
necessities.
Possible means reasonable time.
I
Now,
leave it.
you are wanting that instead of word reasonable, we should also have a timeline.
Timeline.
And like 190 days, 250
By a
days.
purposive interpretation,
That's the argument
that's
precisely.
right. By a purposive interpretation, keeping in view contemporary realities, not functioning in an ivory tower, which my learned friend perhaps wants your lordship to function, and by the felt necessity of the time. These are standard techniques of judicial review and interpretation, which I'm canvassing. What your lordship does is your lordship's prerogative. Now, I come to page 121. On purposive interpretation, just come to the three-judge judgment in Ashok Kumar Gupta. Page 122. The Constitution is the third line. It is not only designed to meet the needs of the day when it is enacted, but also the needs of the altering conditions of the future. It contains so mark these values for purposive dynamic interpretation. It is not designed to meet the needs of the day when it is enacted, but also the needs of the altering conditions of the future. It contains a framework of mechanism for resolution of constitutional disputes. 10 lines below. Concepts may keep changing. These may not be underlined, but a lot should be underlined. They may be not underlined. Concepts may keep changing to expand and elongate the rights. Constitutional issues are not solved by mere appeal to the meaning of the words without an acceptance of their line of growth. 1, 2, 3. The great tides, page 1, 2, 3, seventh line. The great tides and currents which engulf the rest of men do not turn aside in their course and pass the judges idly by. Law should subserve social purpose. Judge must be a jurist endowed with legislative wisdom, historian search, truth, prophet's vision, capacity to respond to the needs of the present, resilience to cope with the demands of the future, and decide objectively, disengaging themselves. Therefore, the judges should adopt purposive interpretation of the dynamic concepts of the Constitution and the act with its interpretive armory to articulate the felt necessities of the time. These are the only things I'm trying to expound on. The judge must also bear in mind that social legislation is not a document for fastidious dialect, but a means of ordering life. Then, Maras, next page, 124 bottom. The judge, therefore, should respond to the human situations to meet the felt necessities of the time and the social needs. Make meaningful the right to life and give effect to the Constitution and the will of the legislature. The court, as the vehicle of transforming the nation's life, should respond to the nation's need, interpret the law with pragmatism, to further public welfare, to make constitutional animations a reality, and interpret the Constitution broadly and liberally, enabling the citizens to enjoy rights. 125 Sakal. It must be borne in mind that the Constitution must be interpreted in a broad way and not in a narrow and pedantic sense. Certain rights have been enshrined in our Constitution as fundamental, and therefore, while considering the nature and content of those rights, the court must not be too astute to interpret the language in so literal a sense as to whittle them down. On the other hand, the court must interpret the Constitution in a manner enable the citizen to enjoy the rights guaranteed by it in the fullest measure, subject, of course, to permissible restrictions. Para 51. Therefore, it is but the duty of the court to supply vitality, blood, and flesh, to balance the competing rights by interpreting the principles to the language or the words contained in the living organic Constitution broadly and liberally. The judicial function of the court is to build up, by judicial statesmanship and judicial review, smooth social change under the rule of law, with a continued past to meet the dominant needs and aspirations of the present. This court, as sentinel on the qui-vive, has been invested with more freedom in the interpretation of the Constitution than in the interpretation of other laws. This court is therefore not bound to accept an interpretation which retards the progress or impedes social integration. It adopts such interpretation to bring about the ideals set down, etc. Then, Malas, in the NCT case at page 126, come to 127. At 127. Therefore, a constitutional court, while adhering to the language employed in the provision, should not abandon the concept of the intention, spirit, and holistic approach and constitutional legitimate expectation which compoundly project a magnificent facet. The court should pose a question to itself whether a straight, literal, and textual approach would annihilate the sense of the great living document which is required to be laser beam to illuminate. If the answer is in the affirmative, then the constitutional court should protect the sense and spirit of the Constitution, taking aid of purposive interpretation, as that is the solemn duty of the constitutional courts as the final arbiters. It is a constitutional summon for performance of duty. The stress has to be on changing society, relevant political values, absence of political prohibition, and legitimacy. Then, Wallace, there are a number of cases given on purposive, which I'm not reading, but your Lordship will mark all the way to page 133 are very important, Wallace, purposive interpretation quotations. Unless and until your Lordship purposively interprets the Constitution in the present context of 200 by stipulating timelines, your lordship would really be reducing it to a mere formality, an expectation of hope, a pious declaration, but no real teeth. That's the submission. At 134, Balas, I've given the last of the interpretation approaches, which is remediless. Remediless. If you have no time limit at 200 and 201, then Balas, there is complete remediless situation, which is what Kalra says at page 134. It's again a constitution bench which may not be written there. Let's write it down. Second half of the boldface verse. I mean, in the boldface, second, starting with as and when. As and when it is found necessary to interfere with the judgment and decree challenged before it, the court can always declare the legal position in general and restrict the ultimate relief to be granted by confining to those before the court only, rather than denying the relief to one and all on account of a procedural lapse or inaction. The only exception to this course would be where the relief granted and the decree ultimately passed would become totally unenforceable and mutually self-destructive and unworkable. As far as possible, courts must always aim to preserve and protect the rights and extend help to enforce them rather than deny relief and thereby render the rights ibi remedium. Where there is a right, there is a remedy, etc.
Or in other words, there can't be a wrong without a remedy.
Well, it's what your lordship says in different ways. Operation successful, patient dies. Parik victory. A declaration and a pious hope of no meaning. A sermon. My lord uses the words in several cases. Manas. Your lordship, Manas, judicially, if I may use a colloquial phrase, would have to judicially walk the talk to effectuate this. Now, Manas, I come to a few peripheral, I will not call them peripheral, the remaining issues very quickly and briefly. Now, question 8 is the 143 question. That are you obliged to seek a 143 reference? Just note the short answer, then Maharaj,
You already at page?
I'm now at page 135. This is Maharaj question 8, which is, now we finished judicial review, we finished timelines. First, we finished discussion on the first day. Now we have another few remaining questions individually. So, question 8 is that is the president required to mandatorily come to your lordship 143 every time there is a doubt or a question? That is the question framed in question 8 at 135 top. May I first answer it, then take your lordship to 2 paras? Very simple. Nobody is saying that the president, governor doesn't have the power, Manas, is mandatorily obliged in every case of such a question to come to your lordship 143. Nobody has said it, nobody is saying it.
That question has arisen.
That question not arisen. I'll tell you.
It has arisen in view of the judgment of the 2 judges.
I'll tell you. That's not.
It's not as if that question has not arisen.
I appreciate. It will not arise.
Division bench holds that, though we are not sitting in an appeal, we can't ignore the fact that the division bench holds that whenever the president has a doubt, the president should mandatorily refer to.
I'm very grateful. That is wrong, Manas. There's a wrong impression given to your lordship. The learned judge, we are not sitting in appeal. First, the question doesn't arise for the simple reason that I agree, everybody agrees that she's not obliged. The learned division bench does not make it mandatory for the president at all. They should if there is something, but they're not at all. See the language now. That's the answer. It's a completely distorted question asked by creating a question where nothing remains. See the judgment straight
If you
away.
are agreeable that this is not mandatory, then there is no.
No,
point
it's
of
not.
arguing for-
It was an empowering para. No, I must satisfy my lords on the judgment also. Give me 1 minute. Come to 139. It's an empowering para. That if the learned president is confused or doubting or wants a query, she may. How can this be, Malas? Kindly read it.
Page?
139 of my para. Your lordship has enough other work to do, Malas, than answering questions. They don't rise on the judgment at all. This reference is the context of a judgment also. We are not an appeal on the judgment, but we are in the context of a judgment.
Of the judgment.
Yes. Yes. We are of the considered view that although the option to refer, mark the word option, to refer under 143 may not be mandatory. It's simple, Malas. This language gives the full option. Why should your lordship be answering questions which are created? Is this question necessary to spend your lordship's time on?
Conclusion,
Read
Yeah.
it further,
Roman
read it
20.
further.
Yes, I'm reading all of it. I've quoted,
Conclusion, Roman 20.
sir, I have quoted it. Allow me to read it.
Conclusion, Roman 20.
Yet the precedent as a measure of prudence.
No, I have to read fully. Please. I'm sorry, I'm not.
I don't understand this anxiety on every sentence.
Whatever little.
Oh.
they have.
Not fair.
There is no interruption from the other side.
Totally unfair.
We expect the same.
Yes,
Totally.
because I didn't miss anything. I didn't selectively read.
What is selective? I have quoted it in my mind. It's very unfair charges being made. It has some restraint. I have quoted it and I have quoted it selectively. We are of the considered view that although the option to refer a bill to this court under 143 may not be mandatory, yet the President, as a measure of prudence, ought to
What
see.
do you mean by ought to?
No, madam, it's an empowering thing.
Ought to.
Well, ought to means the matter.
Ought to means it's a simple English.
Your lordship may clarify in one sentence, this is what it means when we are saying so. Ought to means in the context of a prudence. The previous line and the next line.
The solicitor, please permit him to argue.
Running
I'm
commentary.
talking to him. No, not.
May not be mandatory, followed by a measure of prudence. Read it holistically, Maras. Seek an opinion.
Ought to. You are skipping the word ought to.
No, I'm saying measure of prudence.
And
Ought
you are-
to.
You are directly going to seek an opinion.
No, I'm saying
The word ought to.
measure of prudence ought to. Not mandatory. Your lordship, measure of prudence means your discretion, your option. I have quoted it, brothers, directly. Read the sentence, the whole structure. May not be mandatory is the first. Measure of prudence ought to.
You read it further.
Yes. This is all the more necessary as there is no mechanism at the state level for the governor.
No. First complete that sentence.
Yes.
In respect of bill.
We are of the considered view that although the option to refer a bill to this court under 143 may not be mandatory, yet the President, as a
Don't
matter,
skip any words. While
as a, I don't,
otherwise you will get a pro.
I did not do it earlier and I'm not doing it now.
Yes.
Yet the President as a
You read
measure,
it, therefore we are warning you not to do it.
yet the President as a measure of prudence ought to seek an opinion under the said provision in respect of bills that have been reserved for the consideration on grounds of perceived unconstitutionality. This is all the more necessary as there is no mechanism at the state level for the governor to refer bills to constitutional courts for their advice or opinion thereupon. Under the scheme of the Constitution, as we see it, there is only one possible way for the governor to ascertain the palpable constitutionality of a bill, which is by way of reserving it for the consideration, who in turn is expected to invoke 143. The Constitution is not a maze, but a labyrinth. Although both may semantically appear to be one and the same, yet there is a fine but discernible difference between the two. The difference lies in the fact that in a maze, one may lose their way within the multiple overlapping paths, with the possibility of each of them leading to a dead end. However, in a labyrinth, one eventually finds the way and in the process also comes out more enlightened. So if she wants enlightenment, of course she can come. Similarly, any questions emanating from the Constitution or pertaining thereto, such as constitutional vagaries of a law, must be uncovered through the foresightedness of our Constitution. Whenever a bill is reserved for the governor, by the governor for the President, on the ground of patent unconstitutionality of the nature wherein the exercise of discretion by the governor is permissible, the Constitution expects the President to be the soothsayer, easing the sails for the governor. The invocation of the power of the reference in 143.
Where is the operative part? The direction.
Yes, para 20. Come to para 20. Para 20. at-
Please read it.
Yes,
Read it
12575. Para 20.
Yes, please read it.
Whenever in exercise of the powers under 200, a bill is reserved for the consideration of the President on grounds of patent unconstitutionality that are of such a nature so as to cause peril to the principle of representative democracy, the President must be guided by the fact that it is the constitutional courts which have been entrusted with the responsibility of adjudicating upon the question of constitutionality and legality of an executive or legislative action. Therefore, as a measure of prudence, the President ought to make a reference to this.
Ought to
court.
make a reference.
Ought is there, Malas. I mean, your lordship, may I say straight away, it may take not a minute of lordship time.
If you consider
My case is that.
if you consider that, that's the end of the
My
matter.
case is that. I started by saying so.
Then why unnecessarily have a
No,
debate?
I wanted to say that my reading of this is also that it's an option given. But your lordship may now clarify it. Lordship may clarify it, but the matter ends.
And this observation that, anyway, let's not go into the.
Para 141 is a similar sentiment in 1978 Special Courts Bill. It's not that just, well, the division bench plucked it out of nowhere. A constitution bench at 141 had a similar sentiment. Lordship should know the entire history in a constitutional reference. See what they say. It may not be necessary or even advisable to adopt such a course in all references under 143. But if in some it becomes expedient, as in my opinion in the instant case, I think it saves a lot of public time and remove any technical lacuna, etc. That's an option given to your lordships. Now let us come to questions, page 140. 10, 11 and 13 dealt with together. Page 140. 10, 11 and 13. 10 is the 142 question. Eleven is framed at 140, is a law by the state, a law enforced without the assent of the governor. And 13 is to the powers of the Supreme Court under 142 limited to matters of procedural law, etc. Now, this is important. 142 has been misunderstood. It is in fact one of the few articles which passed without discussion, as well as a clear power entrusted to the body which had maximum trust, accepted by all without controversy. Two amendments were moved, two amendments were cited, never moved. Come to that, please. 142, I'll just read through it. Para 145. 142 empowers the Supreme Court with unfettered, limitless, and self-restrained powers. Mark the word self-restrained. When I say limitless, doesn't mean no self-restraint. To do complete justice in any matter or cause. Considering the very wide ambit, the same is used sparingly and only in those cases where it is necessary to do complete justice. The power is one of self-restraint. Ordinarily, it cannot circumvent and disregard a statutory provision governing a field, with the exception of doing substantive justice. Now, this is 5 judges in the Supreme Court Bar Association. Just read that. The very nature of the power must lead to the court to set limits for itself within which to exercise those powers. And ordinarily, it cannot disregard a statutory provision covering a subject, except perhaps to balance the equities between the conflicting claims of the litigating parties by ironing out the creases in a cause or matter before it. Indeed, this court is not a court of restricted jurisdiction of only dispute settling. It is well recognized and established this court has always been a lawmaker, and its role travels beyond mere dispute settling. It is a problem solver in the nebulous areas, but the substantive statutory provisions dealing with the subject of a given case cannot be altogether ignored. Now, para 147 is important. This was Article 118. Just note this, fellas. 118 has virtually no discussion. I would say no discussion. 2 amendments existed, never moved. And it became 142. Unanimously adopted by the Constituent Assembly, read 147, my note, without any debate or objection at all, implying that the framers of the Constitution deliberately and consciously intended to create a constitutional safety valve in the hands of this court, so that the court may not remain powerless or helpless to do complete justice. It's a insignia of the complete trust in the apex body, which the entire Constitution, there are very few articles which are passed without.
So, in the facts of the case,
that's coming.
Lay down a timeline under 142 to do complete justice.
Yeah.
Can you lay down a straitjacket formula for exercise of the powers by the governor and the president while exercising 142?
Suppose, it is coming here. Suppose your lordship has a statute, forget a constitution, which indirectly impinges. My lords may have a rethink whether you will pass a direct order under 142 touching that statute. Suppose my lord has a clear implicit in some other article that your lordship should not touch 200 with a time limit. It's inexorable. Your lordship may not use 142. Barring that, this is a question not created by us, it's a question referred by the president, by the government. Is there a fetter on your lordships in 142 in such a situation? Is the question. I have not referred the question. this question is raised to create another limitation of some kind. Now let us kindly come to 149. Now this is an interesting judgment, which is when there are two constitutional provisions clashing. 142 and another existing provision. This is very interesting, Manas. Your Lordship has gone to the extent of saying when 142 and a provision are clashing, when the matter is sub judice, 142 will prevail. Just see that. 2 minutes.
How much time will you take on this?
15-20 minutes after lunch, I'll finish.
We'll begin at,
Oh, I see. I didn't know. I'm sorry.
what is likely to take 10, 15 minutes?
Oblige.
You have 2 more days left. And we'll adjust 1.5 hours, which the learned solicitor to the,
2.5 days more.
no, 1.5 hours. So 2.5 days, we include today.
Today is the second day.
Today's second day, 2
Thursday,
more days, and
2.5 hours.
then whatever time you took, 1 hour or 1.5 hours,
1.5 hours. Exactly.
we'll
That
compensate.
will be the
for that.
third day afterwards, which will be 1.5 hours extra. We have enough time, Manas.
And we'll curtail the time from the rejoinder from that.
Your Lordship is now acting like the American courts, Manas. this inordinate delay is repetitive, endemic.
Correct. So 142 can
entrenched.
be exercised in individual cases where necessary.
No, well, let's kindly see.
Why do you want to
Your
put the
lordship
timeline into the
exercises-
constitution?
If your lordship starts exercising this in individual cases of 200, then the very purpose of timeline is gone. There's no point exercising it because the time by which your lordship's mandamus comes, worse still if it's the 226.
No, with council's,
no, but-
pressure, you will get your decision
I
in 2
think my
months, 3
lord
months.
is not in a.
Yes. And no state government has come here to engage,
My lord is not in a.
Tom, Dick and Harry, they will be engaging,
No.
Dr. Singhvi, Mr. Simple,
Malas, we
Mr.
are
Subramaniam,
thankful for the left-handed
Dr.
compliment.
Shankaran
But
and
Malas, it doesn't work in practice. Your lordship is certainly not an ivory tower. Your lordship knows the reality better than we do. All the things your lordship is saying don't happen on the ground. Frequently don't. My lord deals with this situation only when this kind of situation arises. Otherwise, after all, for all these years, my lord did not have. Now, let's,
not required.
the real point my lord is asking is, if we have done it, if I may reformulate my lord's query and answer it, the fact that we have done it in 5 different paradigms which I am giving, we may do it in this case also, but in individual cases, not as a general timeline. That's the question put to me. All the rest of it, Balada, I've answered. I can't re-argue the whole thing. The answer to this question is simple. A paradigm of a 200 delay, which is on the record of legislative assemblies from 1400, 1200, 1800 days in innumerable bills. That's over 3 years, over 5 years, is not met by either a 226 in an individual bill case. There are hundreds of bills passed by the assembly, or a 32, if I'm lucky enough to sustain a 32 in your lordship's court. It takes a minimum of a year. If it's a 226, takes minimum of 3 years. Then what's the point? The governor Malas then has 3 years. You have then become a pocket veto, a killing of the bill, a super chief minister, and you are in effect, your lordship's timeline is not only too little, too late, it has no effect at all. So your lordship's Malas would have to decide that this case arose in a context which is nothing but 7 different paradigms I've given. This Kuldeep Kumar is the 6th paradigm. Only thing is, your lordship dealt with that case. It doesn't at all mean that your lordships can't give a general timeline. That's the submission. And Malas, the basic argument is that your lordships, Malas, would be defeating the very object for which your lordship is undertaking this exercise. The initiative by my lords to give a timeline, even in that individual case, will be defeated if it is limited to individual cases. Now, Malas, Kuldeep Singh I have dealt with. Rajendra Rana was, Malas, another case which was mentioned when I was arguing in the pre-lunch session. The speaker is a persona designata. Only the person who is the speaker can decide tension. This is not the timeline case. It's an interesting case. The speaker is a persona designata. Nobody but him can decide the case. So technically, your lordships must remand back. And remand back by a provision of the 10th schedule, which is not a statute, it's a constitution. My lord said no, we exercise 142 and we decided it.
Again, in an individual case,
That's true. I also,
finding that
Malas,
it has a checker history.
Malas, individual case, I've answered the best of my ability.
There are 2 petitions. First one for
Correct.
for disqualification on the ground of defection, and the second one was on the ground of split. The High Court, the speaker first decides the split without deciding disqualification.
That's right.
The matter goes to before the High Court. One remand,
So 141.
second remand, then it goes to before a full bench. The Chief Justice takes a different view. The other 2 judges take a different view. Then the matter comes to the Supreme Court. 2 months are left.
But Malas,
2 months are left, and the very fact that the court finds that the letter addressed by those 13 persons that we are supporting Mr. Mulayam Singh to form the government itself is sufficient enough to encourage disqualification, and therefore exercises 140.
therefore,
It doesn't say that hereinafter in all matters the speaker shall decide the matter
that point,
in 3 months.
that point is well taken, Malas. I've answered it to the best of my ability already. And let me add, Justice Joseph's judgment in the Election Commission case is an example of a general timeline. In addition to what I've answered, I have said that a general timeline is the most appropriate response to a 200 structure. I have said that without giving a general timeline, the very object of your lordships giving any discipline of time is defeated if your lordship asks me to go to 226 or 32. Those are the 2 answers I've given. A third answer is at page 594 Anu Baranwal, which my lord has noted, where the learned judges gave a scheme for selection. That's a substitute for a timeline, it's a counterpart for a timeline, saying that there is no occupied field. Anu Baranwal at page 594, page 115 internal. The fourth answer is this. If your lordship's millers were to consider not giving a timeline except in individual cases, it will mean that all the principles of providing a teleological interpretation, a purposive interpretation for the contemporary realities, it has to be a general. A contemporary realities and felt necessity has to be a general panacea. Well, the answer cannot be that your lordship will wait for timelines which will exceed, well, as court delays are endemic in this country. Supreme Court is the fastest court. To get a final decision in matters like this, well, it will not take less than a year. Realistically, let's say 6 months, 7 months. Before that, the time which he has kept it back is already held. 7 months is supersonic speed. I did the Punjab case. I did the other 2 cases. It didn't take less than that. So therefore, the entire purpose of timeline goes. They are the only 5 answers as to why, Malas, your lordships should not do the case by case. There is no 6th answer. If your lordship is looking for a judgment which gives a timeline generally in a constitutional matter, the closest is the Election Commission matter. Anu Baranwal at page 115. And Keshav gives it, no, my lord is saying it's an individual case. That's the whole point. My lord says it's an individual case.
What if a election in 3 months?
In 3 months, because of this.
That's what if election was.
So across Malas, 10th schedule, where your lordships can again, it can be distinguished. It's a tribunal.
Tribunal and the,
Everything is
all the
distinguished.
constituencies hold that the speaker does not enjoy the immunity under 112
But,
and
Malas,
112.
the 3-month guideline is a general norm for 10th schedule after the judgment. You may not follow it, the consequences
general
are given.
There are only 2 cases, Keshav and Telangana.
Telangana. No, that's it. I'm coming to, so therefore, no, first case is,
General law, neither Keshav nor laid down. On the contrary, in Telangana, we hold that it is high time
high time.
that the parliament should revisit.
I'll give you the site.
We say that it is again within the domain of the parliament to
Therefore, Malas, a combination of a timeline coupled with a consequence is the best answer for the felt necessity of the time. Now, Malas, page 152 is 145. Is article 145 at page 152. (155), the short answer is, it lasts from 152 to 159. That was only those substantial questions of law which are not referred, which are not decided, may be referred. Not if it is decided is the real answer at para 155 at page 152. Well, in this Abdul Rahim, they say that a substantial question as to interpretation ceases to be that if it is already decided. If it is already decided, it ceases to be a referable question. And bottom of page 153, it is clear that no substantial question of law as to the interpretation arises in the present case, as the very question raised has been decided by a bench of this court consisting of 5 judges. So there is no question of reference if your lordship finds it decided.
So, the decision by 2 judges of this court.
No, that's the next para. That's coming. It's the next page. Next page. Nobody's saying it's final, Malas. It can be referred by the same bench. I am answering the question. The same bench need not refer it where it feels, which it has done here. That is decided. I am saying there's no error. They can refer it. A bench always refers to the lordship. Or in a fresh case, X versus Y. The same question decided in A and B can be referred. Yes. Then,
Coming back to the, just 1 minute.
yes.
Coming back to the previous question that we were deliberating upon,
Timeline.
timeline. Now, the consequences of the timeline have been provided that they will be deemed assent. So the assent is granted by the court. Now, if a bill is granted assent, it becomes law. Right? That can be challenged on the ground of being ultra vires or whatever the provision.
Yes. Yes.
That will again come to this court.
It will come on the
Judicial
merits.
order you grant assent,
It will come on the merits, Malas. Nothing to do with the lordship assent. Deemed assent is a process
Just a
which is
process.
given to.
So this court
My
becomes
lord
part
did
of the legislative process, and then that deemed assent can be challenged by way of a writ petition.
Now, may I answer that?
Independently.
May I answer that? One, your lordship is in no way part of the legislative process. By judicial decision, your lordships would have held, if your lordship upholds, a timeline with a consequence of not following a timeline,
Yes.
which is a judgment of a court, a law of the land under 141, 142, 143,
Correct.
141, 142. 1 minute. Second answer. After having so given a judgment on the law, today it's a division bench judgment, tomorrow it will be a 5-judge bench judgment on some of these questions. Your lordship doesn't whisper a word about the merits of a bill. In this entire adjudication or in that adjudication, not a word is it constitutional or unconstitutional. My lord is
That's
fully
what I said.
empowered.
Then there's that option which the governor has, A, B, and C in the substantive provision of 200
Yes.
is not exercised at all.
No, it is exercised.
No,
but
by
not-
whom?
No, Maras, with respect.
Because he has
Not
failed to
exercised in 3 months.
act in time,
Not exercised.
so
Why
therefore
not?
there is a deemed
Then,
assent.
Maras, in that case, then your lordship will have to say that he can just hold it back as much as he likes. That's the only other answer.
That's a different question.
No, there are only two options, Maras.
That's a different question.
Yes.
The question is whether a general timeline could be,
No, that's. different.
while we exercise the powers under 140.
As I understand it, my lordship, Vikram's question is a little different. Maras. That question, your lordship, is, that's one part. His question, my lord's
The
question is.
question is with regard to the deeming assent.
Two things. No, two things. But my lord is asking two questions. You becoming a part of legislative process and then you judging the bill, the act. That's my lord's question. Well, those are completely non-contradictory. My lord is becoming a nothing but a part of the judicial process, not a legislative process, by holding that timelines are necessary by whatever purposive interpretation, teleological, felt necessities, whatever. Having so held, and the timeline being expired and a deemed assent happening, my lord will look at something totally different, the merits of the bill, if and when challenged. There is no contradiction. And my lord doesn't mix up any separation of power issue. Nothing.
All right.
Marvelous. Now, this, Malas, is the section on Malas 145. In fact, Malas, ironically, one of the bills in the Tamil Nadu list, which was part of the other division bench, is directly under challenge before my lord's Justice Vikramnath's bench, where I am arguing, Malas. Your lordship gave a date last week, some other date about some university UGC. Mr. Mehta is opposing. So that exercise my lord does is not part of a judicial function which happened already. That's a different judicial function. Now, Malas, last point, an important point. Come to page 160. So, Malas, the answer to 145 is there is no question. If the division bench thinks that it is necessary, it may refer. It is not obliged to refer if it finds it's already decided. And, Malas, a second bench can always refer the same question, but leave that and come to the last and most important point, which will take 5-10 minutes, Malas, 160. Now, first see the question. This question has been reformulated
Page?
by Mr. Mehta, 160, and it is not the president's question at all. 1 minute. 160. This is the president's question at 160. Does my lord have 160?
Yes.
Does the Constitution bar any other jurisdiction of the Supreme Court to resolve disputes between the union government and state governments, except by way of a suit under 131? So, Malas, I am going to argue it both ways. It doesn't directly say it does 32 barred by a state. But I am assuming he's right. I'm arguing it both ways. I'm assuming that he's right to raise the question. I'm saying textually as put, it is not raised. I'm arguing that other point also. So first, just give me 3 or 4 minutes on 131, then I'll come to 32. So first, just see 131. The present, so only I'm on 131. The present question does not and cannot arise as 200 cannot be brought in the scope of dispute between the government of India and one or more states or between 2 or more states. For a dispute to be construed as a dispute under 131, such dispute has to be between the government and one or more state or 2 or more states. This is not so, Malas, where a governor is involved. That's the short answer. Then, Malas, I've quoted in the other paras, ornamental functionary, guide, philosopher and friend. Come to, Malas, 165.3 at 161, Justice Krishna Iyer in Maruram. because the precedent is symbolic, I'm only answering 131, Malas. Central government is the reality, even as the governor is the formal head and sole repository of the executive power, but is incapable of acting except on and according to the advice of his council of ministers. Then, Malas 162, the constitutional conclusion is that the governor is but a shorthand expression for the state government, and the president is an abbreviation for the central government. Well, as the next singles case, it's a constitution bench. The governor has a dual role. The first is that of a constitutional head of the state, bound by the advice of his council of ministers. The second is to function as a vital link between him and the union government and the state government. In certain special emergence situations, he may also act as a special representative of the union government. He is not union government. He is not state versus state. He is not state versus union. That's the point being made here. He is required to discharge the functions related to his different roles harmoniously. He is not an employee of the union government, nor the agent of the party in power, nor required to act under dictates of political parties, etc. Then state of Karnataka points out, Malas, the article is attracted only when the parties to the dispute are government or one or more states. And then, Malas, we quote that. I'll skip that, Malas. Just see the next page for a minute. The article is a necessary concomitant, 164, Malas, 164. Article 131 is a necessary concomitant of a federal or a quasi-federal form of government, and it is attracted only when the parties to the dispute are the government of India or one or more states. This is a limitation as to parties. The other limitation as to subject matter flows from the words if and insofar as the dispute involves any question of which the existence or extent of a legal right depends. So these two concurrently have to satisfy 131. It is certainly not satisfied as to parties in the present case. Then 166, Malas, where state of Karnataka in another para is quoted. In an ordinary civil suit, the rejection of a right asserted by the defendant cannot correspondingly and with its own force establish the right claimed by the plaintiff. Proceedings under 131 are adjudicatory of the limits of constitutional power. Middle of that page. The competition in such a proceeding is between two or more governments. Either the one or the other possesses the constitutional power to act. A demarcation and definition. So it's only state and government, and governor will not fall, is in brief what I'm saying here, Malas. I leave this, I've come to the end. Now, Malas, I'm answering the question why Article 32 will lie. Though it is not quite so framed, I reread the question in favor of Mr. Mehta to say that since 131 can lie, other forms like 32 are excluded. I don't think that's the question, but I'm always rereading it against myself. The answer is, Malas, in a very short 2-page note in volume 2.3, which I filed after because my friend argued 2.3 or should be just to 2-page note, and I'm done. My first submission is the article's focus is not on 32 at all. The query's focus is not on 32 at all. Your Lordship need not answer it. Your Lordship need not answer it. Second, 131 doesn't bar. Now the third answer on 32. Come to Malas, page 1, para 2. Murugan's case. Page 1, para 2. May I read, Malas? On the question of maintainability of the writ, according to learned Solicitor General, the same cannot be permitted to be raised in this reference, since the said question was not raised and considered in the order of reference reported as so-and-so. This, Malas, note down, is a writ by the Union of India. This matter which your Lordship is reading in my para 2 is a 32 writ by the Union of India. Then the bottom of that same page. Since the issue raised in the writ cannot be worked out by way of a suit under 131, and since the accused are private parties, the writ is the only remedy available. Now let us just pause. 131 is not applicable in my case. Now there is one government and a governor. I've come in 32. Apply the analogy. Come to page 2 now. Page 2. Having considered the objections raised on the ground of maintainability, having heard the respective counsel on the said question, having regard to the nature of issues which have been referred, We are also convinced that answer to those questions involve substantial questions of law as to the interpretation of 72, 73, 161, 162. This is the second answer. Substantial question of law involved, Lordship should hold it to be maintainable. As various entries as well as corresponding provisions. We do not find it appropriate to reject the reference on the technical narrow ground of maintainability, is answer number 2. Then, Malas, this is a state filing Article 32, is para 3. In state of Uttar Pradesh, where I believe Mr. Mehta appeared, they filed a combined 32 plus 406. But 406 is a substantive provision. 32 is the modality. Modality was 32 only. Transfer of accused from Punjab to Uttar Pradesh under 32. It is next page 3. It is submitted as a writ petition filed by the state is certainly maintainable under 32 for the reason that the administration of criminal justice is bestowed upon the state on behalf of the victims of crime and also on the premise that a crime against a citizen is a crime against the state. I am asking your lordships to underline behalf of the victims of the crime and also on the premise that a crime against the citizen is a crime against the state. This is the larger parens patriae public interest jurisdiction. This is what I am canvassing for my lord's consideration as my submission. This is the argument of the state of UP through Mr. Mehta. Not that there is any estoppel against him. I am not suggesting it at all, just like there is none against me. To maintain the petition under 32, learned counsel placed reliance on Sriharan. Next para. It is further submitted in any event this court may invoke 142 for doing complete justice. Now, whereas in the written submissions, of course, they say in the next para that it, in as much as it is filed under 406, it is maintainable at the instead of the state. Now, 406 is the substantive provision for transfer, not the modality. The modality is 32 only. Now, Mr. Uttar Pradesh's submission, it is submitted this honorable court in the aforesaid judgment. Now, this is the written submission filed in that case by the state in Article 32. Entertain the petition filed, there existed a dispute between center and state. In the present case, state, the dispute is between two states. It is submitted there exists no explicit or implicit bar for filing a petition under 32 by the state. Then, the most important concluding paragraph where I put it together on the concept. And that is para 7. 7. May I read 7? This is the overall conceptual part, then I'm done. The case is cited after that. Further, the parens patriae doctrine empowers the state government to be a custodian of the fundamental rights of its citizens, enables it to take all necessary steps to safeguard it. There are diverse facets to this submission. A bill is the sovereign expression of the state acting in public interest for the welfare of its citizens. Secondly, when a state challenges egregious delays by the governor, it seeks to promote public interest of each citizen of the state. Thirdly, this exercise inherently seeks to promote and protect the fundamental rights of each state resident citizen. Fourthly, when the state so acts, it is acting for the collectivity of its inhabitants and additionally exercising parens patriae. Lastly, none of these facets would be excluded from part 3. The case for this is Charan Lal Sahu Malas. The first sentence is parens patriae. They start. And the next page, Malas, is this court also recognized the concept of persons relying on parens patriae. Then, Malas, they completely discuss parens patriae, which I'll not read, but the entire jurisprudence is given and quoted by me over Malas 5 pages. I've underlined Malas. It saves time if I don't read it. But parens patriae is Malas, the jurisprudence explained, elaborated, how it evolved, what are the limits. I certainly say, Malas, that in view of para 7, the 5 reasons I've given or the 4 reasons I've given, you have a collectivity, Malas, of public interest and parens patriae, which would make this petition. And indeed, the state is otherwise remediless. It's not a 131 dispute. You always can say go in a 32, in a 226. That's a different matter. But that is not the object, your lordships. 226 alternative does not bar your 32 in any manner. Your lordship may not entertain a 232. It never bars you. I'm extremely grateful, deeply obliged. I'll join in shortly.
Yeah, I got it. I got it. Because I'm appearing for the state of West Bengal, Manas. I was to also appear for Karnataka, but if I do that, my learned friend will not get time to address your lordship. So I'm giving up, Manas, and ask my learned friend to appear for Karnataka. Because may I just broadly tell your lordships what my submissions are going to be, because lots has already been said, Manas. So we'll need to encapsulate, Manas, our submissions so that everybody gets a chance to argue. Manas, what is your lordships considering today? If you look at 200 and 201, the first question you have to ask yourself is, what's the nature of the power exercised by the governor in 200? Is it legislative? Is it executive? What's the nature of the power exercised by the president in 201 when the matter goes to him for consideration? Is that on the aid and advice of the Council of Ministers at the center, or is it his personal power? Those are the two fundamental questions that your lordships will have to ask yourself. I'll assume for a moment, Malad, that it's an absolute executive power. Let's assume against myself. So consider this, Malad, a conundrum, which is a constitutional conundrum that your lordships will have to face. A legislature in a state is reference to a item in list 2, say distribution of electricity, or an exclusive item in list 2 passes the legislation. That's the will of the people, and that's a sovereign act. So your lordships will have to come to the conclusion to decide against me that that sovereign act of the legislature need not be implemented by the executive. He can withhold it. So for the first time in the history of constitutional law in this country, your lordships would hold that the will of the people need not be implemented because the governor chooses to withhold the bill. It's a proposition, Malad, which is unaccepted under any principle of constitutional law. It cannot be. Why, Malad? Now let me give your lordships why. If you look at the theme of the Constitution throughout, in respect of the executive chapter, Malad's in relation to states, or the executive chapter in relation to union, you will find that the executive at no stage has any legislative power. If it comes to the executive in the union, Mullahs, the president will act on the aid and advice of the Council of Ministers. President has no individual function. When it comes to the state, Mullahs, the governor will act on the aid and advice of the Council of Ministers. The governor has no individual function. If at all, the governor has two functions, Mullahs, which are somewhat different under the Constitution itself, which is 356. But that's a recommendatory function. It's not a decisive function. The governor will recommend that the functioning of the state is such that that cannot function under the provisions of the Constitution. Who decides? The government of India. Who decides finally whether that's right or wrong, Your Lordships? So you have to address that question first, Mullah. Let's forget about case law. Fundamental constitutional law. 356 is one such power. 161 is grant of pardon, again, exercised on the aid and advice of the Council of Ministers. And 311(2) is another power. 311(2). Inquiry not necessary to dismiss a government servant because of the satisfaction of the governor. Again, on the aid and advice. Give me one provision in this constitution, one, that allows the governor to exercise any power which thwarts a legislation. We'll come to timelines later, but at the moment, I'm not concerned with. So you have in 200, in a part of 200, a power to allow the executive, namely the governor, who doesn't have to act on the aid and advice of the Council of Ministers. He doesn't consult the union government because he has no right to consult the union government, but he will just withhold the bill. Well, such a proposition is untenable from any standpoint. Point number one. Two, what choices does he have? Let's now assume, Mullah, in my favor. I assumed against myself, Mullah, and made my point. Let's assume in my favor that he has no power to withhold. Where do we go from here? He then has to either send it back. Now, Dr. Singhi made 3 alternative propositions on that, but I'll not go into that for the moment. He has one possibility to send it back to say that you reconsider the bill or you pass the bill with certain amendments. That's what's reflected in the first proviso. Right, Mal? And that he has to do as soon as possible. Or he sends it to the president for his consideration. That president means the government of India, not president in his personal capacity or her personal capacity. That's the only 2 options he has. Now, if he exercises the first option, namely he sends it back, let's assume he exercises that option, he has to do it when? As soon as possible. Let's please reflect on the word possible. It's not just soon. What can a governor have an impediment on not to consider the bill forthwith? He has no impediment. He's holding a gubernatorial office. The will of the legislature is reflected in that bill has come to him. Certain DA allowances are to be given to somebody, or that would be a money bill. But if it's a non-money bill, some mullahs in the field of education, mullahs, something has to be done. In the area of reservation, mullahs, as your lordship knows, under the Right to Education Act, and these are state acts now, mullahs, you can reserve for certain categories of individuals, mullahs. Supposing the government wants that children or orphans should also be included in the reserved category. Children or orphans. I'll give an example, mullahs. So, mullahs, how long will the governor have to take for that? When you say as soon as possible, what would be impossible for the governor, mullahs, to hold it back? That too, your lordships will have to consider. Forget about the timeline for the moment, mullahs. Just look at the words of the Constitution. Timelines will come later, mullahs. Let's look at the other scenario, that the matter is sent to the president for consideration. Now, what did the president do? As soon as possible doesn't apply to him.
So in sending it to the president, there would be an advice of the Council of Ministers?
No,
No.
Not, that's not my argument.
We just wanted to know.
Well, that's the
The
argument of
governor
Dr.
state
Singh.
that as to whether it is to be sent to the president or not.
No, correct. I'll tell your lordships.
Yes.
I'll tell your lordships. Well, what will happen in the process is that he feels that this may be repugnant.
Therefore, he is applying his mind.
He has to, Manoj. I'm, that's not, Doctor, I'm not following Dr. Singhvi's argument there. He has to apply his mind.
So deal with the aid and advise aspect of it first.
I'm sorry?
Aid and advise aspect of it, and also the aspect relating to discretion.
I'll come to
Regards
this.
the governor first, because after answering that question, then the second issue will arise.
Yes, yes.
Since he has absolutely
Manoj,
no discretion at all.
As far as the aid and advice is concerned, Manoj, when it comes to the right of the governor to send it back, Manoj, there is inherent evidence by reading the provision itself that he does in his capacity as governor, feeling that it might be repugnant to a central legislation.
Takes his own call.
That's my
That's not based on aid and advice.
It can't possibly be. It can't possibly be.
Completely contrary to Dr. Singh.
That was the first alternative of Dr. Singhvi's submission.
Hear what you have and to it.
That he suggested, that everything has to be on the aid and advice.
So normally, because a bill before it is presented to the legislature would come through the cabinet.
Presented to the governor.
No,
Before,
before the bill is.
I'm going to come to that.
Unless it is a private bill.
Right. I'm going to come to that. That's a second proposition, Malas. Broad, at the moment, I'm not dealing with the article, Malas. We're just broadly giving your lordship the submission. Your lordship is right, Malas. That's the other thing. The basic principle of constitutional law in matters of this nature, when there is interaction between the executive and the legislature, is that, Malas, there must be a level of amity and cooperation to make the constitution work. Your lordship sitting, Malas, in this court has to ensure that you interpret the constitution to ensure that it works. Not that it does not work. Not that the governor says, I will not allow this to go forward.
25 years of
Yes, exactly.
constitution.
Exactly.
Country has worked.
Exactly.
Not as if it has
Exactly.
worked.
Right. In Malad, no principle of constitutional law which allows a breakdown of constitutional machinery. There is no such principle of constitutional law. These are fundamental mullahs that the court will knows and looks at mullahs when deciding a provision. So mullahs, you can't have a situation where the governor says, I just sit back, I don't want to do anything. What is to be done thereafter is a separate issue, mullahs. But if you look at 200 carefully, you will find that the governor will either send it back with amendments, with suggested amendments, or he'll send it back for reconsideration. And then the legislature will then pass it if it feels that it should be passed. Now, if the first stage is on aid and advice of council of ministers that he'll send it back, there's a question of if it will be passed then. There's no question of if the legislature feels it should be passed. That's what 200 says. So there is inherent evidence in 200 itself that that little exercise of power is by the governor.
So what considerations weigh with the governor when he takes a decision to send it
Well,
back
that's right.
or not to send it back?
Correct. I appreciate that.
That's the pathology of decision making as against that of an executive.
But that decision
Where
making is not adjudication.
Our question is that what
Yes.
troubling us is that when he takes a decision of this nature, is it a logical, syllogistic, or a court type of a logic that he would follow? Or are there any considerations like deliberative, consultative, or any other methodologies by which he will have to apply his mind to send it back?
Well, let's take an example. I appreciate what my lord. Let me take an example. Forget the governor, the president. But many a time bills comes to the president.
President's position is completely different. We're not at the president, we are governor's position.
No, I'm answering that. In the light of what my lord has asked me, I'm giving you an example, because the president has taken the advice of the attorney general on several occasions, even if the bill is with him. Correct. So similarly, but he can take advice of the advocate general saying, this is what I feel, there's a problem with this. What do you think? He can do that. He can take the advice of a private lawyer. The president does it. We've seen it in action, Malad. The president is not exercising his personal, the president is just considering, Malad. He's not just a rubber stamp ultimately.
There have been instances where even senior counsels have been considered.
Yes. Therefore, my lords ask me this question, the answer is simple. He is not taking any decision. After all, he has a mind, he's the president, he's the governor, he has a mind of his own. He genuinely may believe that there is something that needs to be addressed. He is not the decision-making authority. He doesn't act as the judge. He can't reject the bill. He has no power to do that. He can't withhold it. He can either send it upstairs, Malad, or he can send it back to the legislature.
You are only on the issue of withholding?
Yes.
Are you only confined to withholding?
No, I'm saying withholding, Malad, my broad answer, and I'll take your ships through Malad, the details.
No, that's right.
I'm the other one. Withholding, he cannot withhold. Malad. That question doesn't arise of withholding because he'll be overriding the will of the legislature. It's anathema to the Constitution. There's no question of withholding. The question is, if he is not withholding, what then are his options? That's the point that I was trying to address at this point. His options are either to send it to the president or send it back to the legislature. Legislature with suggestions, right? By exercising a limited amount, because it is as soon as possible. By exercising a limited amount of application of mind, should I send it back or should I just give assent to it? And if it does send it back, Mullah, the legislature passes it and it's cleared. That's the law. Right. Now, Mullah, he sends it to the president. What's the focus there? What will the president do for his consideration? That's the last line of 201, Mullah. What does that mean? Can he sit? Because there the president is the council of ministers. There the president has no leeway like the governor does in 200. So can the government of India sit on the bill? It's executive again. What principle applies to the government of India? As soon as possible. So there is an element of urgency. Why? Because the legislature is sovereign. And a legislative act of the sovereign cannot be withheld, must be passed as soon as possible. And there's no impossibility in dealing with it. So if your lordship says forthwith, that's enough. We don't have to say 3 months, 4 months, 6 months, 8 months. Forthwith. Because that's the nature of the exercise. That's what, now, Malaj, as my Lord the Chief Justice mentioned to me, what happens, Malaj? What happens in Parliament? I've gone through it several times over, Malaj. If a department of the government of India wants to introduce a bill, what happens? Malaj, the department prepares a draft and circulates it to all the ministries who may be affected. If it's something to do with fertilizers, they'll circulate it to the Ministry of Health, Ministry of whatever. And Malaj, then what happens is that after comments will come and then comments will be collated, Malaj. Then ultimately some kind of final draft will be made and then it is sent to the Ministry of Law. And then the Ministry of Law will look at it, Malaj. And then ultimately a bill is drafted in its entirety and then it goes to the cabinet. Now, if the bill has really no problems with it, it will pass. It will be passed. But the cabinet may think, no, this is a matter which needs to actually go to a group of ministers. Why I'm giving your lordships that this is what happens. It's a collaborative exercise of the executive, ultimately resulting in the introduction of the bill. Right? So that collaborative exercise is done by the executive. So it's not as if the legislature is going to pass a bill in relation to foreign affairs. The kind of examples, Mullah, that were given by the solicitor. Mullah, I can't understand this logic. My learned friend says, don't deal with facts in the cases that are before other courts or in these states. But I'll give you facts that I will deal with. He can't have it both ways. He's given assumptions, or he's given any number of facts. He argued that, Mullah.
He said, in such matters.
What such matter means what? Facts. He is now assuming a fact, creating a chimera, then arguing on logic that, look, if this happens, what is the poor governor to do? So you can't have it both ways. He can't give examples of that nature which have not happened in the history of this country and of parliament and of the legislature since independence. And those are the examples that he has given, and he's made an argument on the basis of that. He can't do that. If he is to argue it, he must argue it bereft of such, sorry, I don't want to use a harsh word, such example. So, therefore, the president too, and the president here is the government of India, must act and deal with the bill as soon as possible. Now, let's assume, mullahs, that my learned friend's argument is right, that the governor acts in his own capacity. Because if your lordship knows, mullahs, the argument of 361, mullahs, that is being made. And that's a very interesting argument. If you look at the judgments of the court under 361, you will find this. When it comes to 356, governor doesn't have to be made a party, because the order is passed by the government of India. So government of India will defend the governor. That's why you say government need not be made a party. If it comes to mullahs 161, again the governor need not be a party. Why? Because the order can be defended by the government. If it comes to 311(2), again the governor is not a party, because it will be defended by the government. But if it's the government's own power, the government cannot defend him. So, apropos the debate that took place with Dr. Singhvi, if you were to challenge that order, mullahs, the governor will say, I cannot be asked. And there will be no government of India to defend him. So the 226 cannot be filed. If you hold that withholding consent is an absolute power of the governor, it will lead to absurdity. It will lead to lack of function of the constitution itself. Mullahs, this constitution, its genesis is in history, but its alignment is with the future. And who decides the future of this country? You five, in this case. The future of India is at stake if you give such powers to the governor. Because it will lead to these absurd situations. And even 361 is wrongly read, mullahs. If you look at 361 carefully, and I'll come to that tomorrow when I deal with it. If you look at 361 carefully, you will find this. The first part of 361 says that he is not answerable. Then it goes on to say, but he can be impeached. He can be removed. And then the proviso comes. The gravamen of 361 is to make sure that he will not be answerable to an act. Just read 351 with me. It's very interesting. And it's not been interpreted like this ever before, brothers. Yeah, just let's. If I may, brothers, with your lordship's permission.
Yes.
The president or the governor or Raj Pramukh of a state shall not be answerable to any court for the exercise and performance of the powers and duties of his office or for any act done or purporting to be done by him in the exercise and performance of those powers and duties. Then a colon. Provided that the conduct of the president may be brought under review by any court, tribunal, or body appointed or designated by either House of Parliament for the investigation of a charge under 61. Provided further that nothing in this clause shall be construed as restricting the right of the person to bring appropriate proceedings against the government of India or the government of the state, which is 356, 311(2), and 161. There the government will answer. But if it's the governor alone, it can't, this proviso will not work. No criminal proceedings shall be instituted or continued. So much as your lordship sees, removal provision is in the proviso, criminal proceedings in subsection, sub-article 2, and no process of arrest is against sub-article 3. And no civil proceedings shall be instituted during his term, or if it's defamation or something like that, will not be done till the term is over. So you have criminal proceedings, civil proceedings to which he is completely protected. But not for an official act, according to me, Malaz, not for an official act. Not for an official act in which, Malaz, the government of India can defend him.
Rameshwar Prasad looked into all that. Rameshwar Prasad's.
Correct, but the true import of 361 is really immunity from personal attack. That's what it is. That's what really 361 is all about. He's answerable. He's in every respect, he's answerable. But answerable not in his personal capacity, but by the government. Because it's the government which actually takes the decision. But if you interpret 200 in this way, it will not operate. You will not be allowed to operate, Malaj. Because how will I file a petition against the governor? But the governor acts on my aid and advice, Malaj. So who will stand up for the governor? Government of India can't stand up. Government of the state can't stand up.
Interestingly, there's no provision.
It's very, very interesting, Malaj.
Second to Article 70. 21, if I'm not wrong.
Similar to 61.
No provision similar to 61. That's correct.
61 for the government.
Correct. Absolutely.
So therefore, because if the appointment is by the union, by the pleasure of the president.
And Willis, look at his oath of office. Look at the oath of office of the governor. It's very interesting, Willis. Kindly see. Which? 160? No, oath of office.
That's the reason why they won't stand on a different footing, president and the government.
No. 150. Very interesting, Willis. Kindly have a look at this oath of office, which my learned friend read. And I'll show you, Willis, the difference between that.
159.
15. Very interesting, Willis. I so and so. Sorry, Willis. Solemnly affirm that I will faithfully execute the office of the governor or discharge the functions of the governor, name of the state, and will be to the best of my ability preserve, protect, and defend the Constitution and the law. And I will devote myself to the service and well-being of the people of the state. Just read the oath, 159. That is very interesting, Malad. He owes his allegiance to the state, which gives you an indication, Malad, as to what his constitutional responsibility is. And if you differentiate with the oath taken, Malad, by ministers, it's very interesting, Malad. See that. Third schedule, Malad. Very interesting.
As compared to the.
Yes.
That to the people of and well-being of the people of India.
Give it to me. 60. Yes, ma'am. Yes, it says. Very oath of the minister says, I will bear true and solemnly affirm faith and allegiance to the Constitution of India. There it is, defend, preserve, and protect. Preserve, protect, and defend. Which means he has no actual role in the functioning of the government. Here it is, owe allegiance to the Constitution of India as by law established, that I will uphold the sovereignty and integrity of India, because he is a sovereign himself, so he will not take that oath, the governor and the president. that I will faithfully and consciously discharge my duties as a minister. That oath will not be taken by the governor because he has no duties to discharge. He's only a constitutional titular head. As a minister for the union, and that I will do right in all
I
matter
will
of people.
faithfully execute the office of governor or discharge the functions of the governor.
Correct. And see further, Maharaj, that I will do right in all manner of people in accordance with the constitution and the laws. Because he is actually the executive delivering the will of the legislature to the people of the country. He is the vehicle. The executive is the vehicle to uphold the will of the people reflected in the legislature, which is a sovereign act of the legislature. That's why the nature of the oaths are different, where it is preserve, protect, and defend. That's partly an answer to my Lord's question, just Narasimha's question, as to what does he do if he thinks that this bill, something is not right with this bill, because he has to preserve, protect, and defend the Constitution. He may think there's something wrong with it. So these are indications of the nature of the responsibilities of the governor. So forget the word veto. And whereas the third aspect your lordships will have to consider also is what do you mean by discretion? There is no concept like discretion in 200. Where is the word discretion used in 200? Is either withhold assent, grant assent, refer it to the president, refer it to the legislature. Where is the discretion? The whole argument was made on discretion.
Discretion either to do one of these three things.
No, my lords, no. Discretion is advisedly used under 163(2) by or under this constitution. Read 163(2), my lords, with respect, with me. One or both. Lightly see. There shall be, I'm sorry, just read 163(1), 163(2). There shall be a council of ministers with the chief minister as the head to aid and advise the governor in the exercise of his functions, except insofar as he is by or under this constitution required to exercise his functions or any of them in his discretion.
Therefore, if you say that in 200, he does not need the aid and advice of the council of ministers to take a decision whether or not to grant, withhold, or refer it to the president, reserve it for referring to the president, or to send it back, then he is exercising his discretion.
That your lordships are now using a word of art to understand what exercise of power. No, but that's a constitutional duty. I'm sorry, Malas. That the governor is exercising a constitutional duty in his discretion by or under this constitution.
Correct.
Kindly come to 671A. Just come with, read with me.
Let us understand the.
Yes. Kindly.
Let us be clear on that.
I'll straight away, Malas, indicate to your lordships the argument. 371A.
How does he take the decision on what basis? One application of mine?
By or under his discretion has been explained, Malas, thoroughly in Navam Rebia. Please, I'll demonstrate that, Malas. 371A. What does discretion mean in 163(1)? By or under the Constitution?
Yes.
Kindly come to 371A. It says, notwithstanding anything in this Constitution, no act of Parliament in respect of religion, leave that out. Let's kindly come to B. The governor of Nagaland shall have special responsibility. Now note this, with respect to law and order in the state of Nagaland. For so long as in his opinion, internal disturbances occurring in the Naga Hills Swinsang area immediately before the formation of the state continue therein or any part thereof, and in the discharge of his functions in relation thereto. And the governor shall, after consulting the council of ministers, exercise his individual judgment as to the action to be taken. Now the proviso, provided that if any question arises, whether any matter is or is not a matter, as respects which the governor is under the subclause required to act in the exercise of his individual judgment, the decision of the governor in his discretion shall be final.
This is correlates 163
163(1).
No, two.
Two.
Sub-article 2, 163, sub-article 2,
It is
identical.
going to be final.
No, but that's been interpreted. I'm sorry, Your Lordship, that's been interpreted in Oneindia that 163(2) there is no individual power of the governor at all. I'll show you the passage in Oneindia.
Slight difference.
Therefore, Manoj, by and under this constitution is 371A, 371H. And why, Manoj? It relates to law and order.
Particular.
Yes, yes. Your Lordships are putting to me this question rightly, that also can be in his discretion. But that's not the meaning of 163(1). That's a constitutional right or power or duty or whatever you may call it. The same, and this also, this is executive power. Kindly notice this. 371A is executive power. It is not legislative power. It's law and order. Just like 144. When somebody comes, what if 144 should be imposed, or this should happen, or that should happen? What do you
Part of the expression there in the proviso, which is very uniquely worded.
Yes.
Under 371A, clause required to act in exercise of his individual judgment.
Yes.
Which is very, very different from that of sub-article 2. Sub-article 2 almost identical, except that it doesn't use in the first part in exercise of his individual judgment. But rest of the article is one and the same.
Correct. Now, this argument was made in Oneindia by counsel saying that 163(2) is the power which allows the governor to use his discretion. And that was in the context of what, Mullah? In the context of summoning the house. Your Lordship, remember in Oneindia what happened was that the governor, Mullah, summoned the house without the aid and advice of the Council of Ministers. He summoned the house, then he said, this is the agenda of the house.
Right.
This is going to be the agenda of the house. Then he said, this item should be the item which should be voted first in that agenda. In that context, the argument made by counsel for the governor was that 163(2) is his individual judgment, gives him that right. Court said nothing doing, right? That is only by or under this constitution relating to specific articles of the constitution. 371A is one of them, referred to in Oneindia. So there is no such thing as discretion in Article 200. It's completely alien to 200. Now, having said that, you will also have to understand, and your Lordships will have to probably reflect over it, even if there is discretion under the Constitution to be exercised by the constitutional authority, there are contours within which he must exercise or she must exercise that discretion. That's not the free will of the governor, that in my discretion, I will withhold the bill. That will be struck down immediately. That discretion has to be exercised in the contours of the concept of discretion.
The concept of discretion under sub-article 2, though repeatedly said, it is subject to those which are specifically provided in the Constitution. Just wait.
Yes.
In the Constitution, invariably, all those arose and got identified by virtue of interpretation of the court. So we have by the court a process by which we have identified and said this is a specific constitutional provision by virtue of which it can be said that it is a discretion vested in him by virtue of the Constitution.
Right.
So it is in that same line that we will have to see it's an inquiry by the court whether 200 keeps a kind of a discretion in it or not. It's an inquiry. And constitutional larger principles, as you have indicated, in principles such as democracy, principles such as the federalism as adopted in state of Punjab's case, are guiding principles on the basis of which you would see and interpret whether such a discretion exists or not.
Well, my humble submission to your Lordship says that discretion is a concept alien to 200, and I will try and make that good.
So discretion as indicated,
No, but your lordship
Yeah.
is saying that you will have to see as a matter of interpretation
Yes,
whether
yes.
that concept can be incorporated in 200 as a matter of interpretation.
Constitution as have been provided in the constitution is the expression in sub-article.
But by or under?
By or under.
No, Malaj, it's not by the
They have
constitution.
not identified those specific.
They have,
articles
Malaj.
right here. in the-
Abhinam Arabia it identifies them. 239(2), 239(2), 371A, 371H. 200 is not there. 200 is not there.
Yes, we're right, we are on that point.
So therefore, the point is, it says by or under the constitution. Shamsher Singh majority says the same thing. The point I'm making is, why do you want to incorporate something that clearly is not there in the constitution? And if you were to exercise, he were to exercise or she were to exercise that power of discretion, what is the... If he or she were to exercise that power of discretion, what are the contours reflected in 200 by which that exercise can be done? None.
Therefore, again, the same question, Mr. Sipal, how does the governor take a decision under 201? First,
Well, I tell your lordship the problem there.
it's a
And I've,
preemptive provision.
well, I've reflected on it for a long time. I'll show you why. Now read 200 with me
Yes,
for a minute. The problem that arises, and for the lordship too, you may even reject my argument, but there's something to be said for that. Kindly see.
we want to understand whatever.
Yes. Now see 200 with me, Malaj. Read the proviso. I now assume that the government will aid and advise the council of ministers, the government and aid and advise the governor. I'll assume that now, before he sends it back.
I put you that question earlier, whether the governor acts on the aid and advice of the council of ministers while taking a decision under 200. You said no, correct?
No, I said no, wait the amendments
on
only.
Council of Ministers.
Wait
then
the
how is
amendments.
he taking that decision?
Now kindly see that. Read with me.
Either you
Read
say that he is acting on the aid and advice of the council of ministers.
read the proviso with me for a minute, Farah. Read it.
No, not
Provided.
the proviso, the main part, the first part.
All right, I'll read. When a bill has been passed by the Legislative Assembly of a state, or in the case of a state having a legislative council, has passed the bill by both houses of the legislature of the state, it shall be presented to the governor, and the governor shall declare.
Governor shall
So my
declare.
lord's question not been answered. What does declare mean? Your lordship, my lord Justice Suryakant asked the question, not been answered. I'll try and answer that. Declare either that he assents to the bill, correct? No problem. Or that he withholds assent, no problem. Therefrom, or that he reserves the bill for the consideration of the president, correct?
How does he take any of these three decisions?
Just see, read the proviso. I'll come to that just now. For a minute. Let me answer this. I'll answer what my lord is putting to me. Read the proviso. Provided that the governor may, as soon as possible after the presentation.
This is not a mandatory requirement for him. It may, if he grants assent, then there is no need for the proviso. The proviso becomes irrelevant then.
That's if.
So, or if he reserves for the president, then also the proviso is not relevant at this
Correct.
stage.
Now, let me answer that.
How does he take that decision
All
of
right.
whether reserving it for the president
All
or
right. So there
granting
are,
assent or withholding it?
so there are two interpretations to that. Number one, that
On
the-
whose advice and who?
Yes,
Is
exactly.
it his own wisdom?
That's right. There are two interpretations. That's why I'm saying either the government of the day tells him, reserve it for the consideration of the president.
Then is on the aid and advice of the?
Yes, that's Dr. Singhvi's first alternative argument.
Said, no.
I say no, of course. It's my argument, no. Because if he's going to refer it to the president on aid and advice of council of ministers, why would the bill be sent to him? So
Correct.
therefore it's obvious. Well, this is obvious. It's a no-brainer, well, according to me. Therefore, there is an element, not of discretion, of a constitutional responsibility.
That's right.
That's what I'm saying. Now read the proviso with me. It's interesting. Provided that, I wanted to liven up the proceedings, therefore I'm not reading through judgments first.
Yes, that's right, it's more interesting.
Provided that the governor may, as soon as possible, after the presentation to him of the bill for assent, return the bill, and if it is not a money bill, together with a message requesting that the House or Houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, And when a bill is so returned, the House or Houses shall reconsider the bill accordingly. And if the bill is passed again, now you read the word if the bill is passed again. Malad, if the bill is returned on the aid and advice, where's the question of if the bill is passed again?
Then again, the whole.
So therefore, I am not agreeing with the first argument of Dr. Singhvi, Malad. This is it's my case, Malad.
Then how does he write his message? That also, I guess.
That's therefore, there is that play, that's that constitutional responsibility. After all, as I said, he's not a postman. There, I agree with him. There is some play in the joints.
So agree that he's not a postman.
He's certainly not a postman.
Correct.
Certainly not a postman. But there is that limited play in the joints. What is that play? If he feels that this requires the consideration of the president, he can consult lawyers, he can consult and refer it to the president. Or if he feels that some amendments are required, or that's a suggestion because he's not the deciding authority. So he sends it back. That's perfectly workable. That's what makes the Constitution work. If it's only on the aid and advice of the Council of Ministers with no leeway, what's the point of having a governor then? Then how will it work? It will only work through a collaborative exercise of constitutional authorities.
The correct word.
That's how we must interpret the Constitution. Otherwise, Malad,
All right.
yes. Now, Malad, just see some constitutional principles. Then I'll sort of, what's the time?
It's a lot of time.
Enough time. Now, kindly see, Malad. As I said, no, just your lordships may just note these principles, Malad, like this, so that your lordships may. There is no principle of constitutional law.
Is there in your written note?
I can put it, Malad, if your lordships.
So I've already done it. The
Yes, we have already, we have got your written note.
initial.
No, Malad, that should be effaced, Malad, because
New proposal.
this is a new, Malad, what happened?
Today only it has been uploaded.
Just now,
Yes, sir.
Alright.
The same one.
the same,
2.4,
No, you want
2.4.
to make some propositions which are new.
which are new.
The reason is, Malad, when I introduced that particular note, I didn't hear the learned Solicitor General's arguments. So I have to really deal with, very serious arguments made by him. So I had to make a new note.
This
And also, we did not have the benefit of listening to Dr. Singhvi's argument.
I also didn't have the benefit of that.
1.4. 1.4 is
2.4.
2.4 is
2.4, Malad. 2.4 are my submissions. This is not included. Not included. I'll include it. Malad, but let me read it then. I'll read them and then I'll include it. It says there is no principle of constitutional law which allows for a breakdown of constitutional machinery. So this blanket, I will not withhold consent, is just not on. Two.
So I will withhold the consent endlessly.
Yeah, just not on. It is anathema to the Constitution, the very concept of withholding assent. Timeline is a different issue. I'll come to that.
You cannot sit over the wisdom of the legislature or the.
That's right.
Agree.
Two, each organ of the state must function to ensure that it does not act as an impediment in the functioning of the other organ. That's the second principle of constitutional law.
no organ can impair the functioning of the other.
Exactly. And in the context of separation of powers, you can't argue that the executive has a legislative role to play. It's anathema. How can you argue that? It will go against federal principles. Of course, we have a new definition of federalism, which your lordships also will consider. Three, the working of a constitution is a collaborative constitutional exercise. It's not combative. This is as if it's combative. I will withhold it. It is non-justiciable. So you cannot even ask me. That's a combative position, not a collaborative position. Any disputes in respect thereof requires the Supreme Court of India to be the final arbiter. While interpreting the Constitution, the fundamental premise of a court is to ensure that each pillar of the state under the Constitution exercises powers in accordance with the provisions thereof and discharges its duties as provided for within the constitutional framework, not outside it. While interpreting the Constitution, the court must, as a matter of principle, lean towards interpreting the words therein to allow for solutions, to make the provisions of the Constitution workable and not lean toward the constitutional interpretation that makes it unworkable. And no organ of the state has absolute power. That's the other very, very sound constitutional principle. No organ of the state, neither the legislature nor the
Executive, not the judiciary.
no, only one absolute power, master of the roster. That's absolute power.
That's probably them.
That's absolute power. Nobody can challenge it.
That is done with great amount
In a
of,
lighter way, in a lighter way.
done with a great amount of restraint.
I don't, Manoj, don't take it amiss. I just said it in a lighter. I agree. Manoj. Since your lordships put it to me,
I have only now 2 months or something left. It's a message for 3 of them.
And I have definitely not heard what you asked.
I am far away.
miles to go.
Forget by the time your lordship see.
Really, if I have heard.
Then the next is responsibilities of all organs of the state functioning under the Constitution must be guided by the principle of preserving, not thwarting the democratic process. They must preserve the democratic process. And a judicial interpretation of the Constitution cannot nullify, defeat, or distort a constitutional provision by so interpreting the Constitution as to prevent an act of the executive from not being amenable to judicial accountability. You can't interpret and say, this is not amenable to judicial accountability because I have some absolute power. And constitutional provisions are required to be interpreted and understood with an object-oriented role that Dr. Singhvi has already mentioned, Bharat. And when interpreting the Constitution, which is meant to endure the test of time, given the stresses and strains of changing circumstances, the court's approach should provide for a workable resolution consistent with the object underlying the constitutional provision. So these are broad principles. They are supported by judgments, Bharat. I'll add it in the note for your lordships. Now let's have a look at, let's now go to the provision itself. Kindly come to my note. Yeah. Now, the other thing about justiciability, which the other argument brought, I'll just indicate what my submission is going to be there. My learned friend's submission was that I am not saying there's no judicial review. All I'm saying is just not justiciable. It's just not justiciable because there are no manageable standards. That's what he said. There are no manageable standards to make it justiciable.
Unlike 356.
Unlike 356. But 356 has the word satisfaction. Your lordship knows 356. It is the satisfaction of the governor. 311(2) is the satisfaction of the governor. Now, satisfaction implies an element of subjectivity. And therefore, in Boma and other cases, your lordships have held that, look, we will go thus far, but no further. That's absent in 200. There is no subjective element there. Therefore, the nature of the exercise of power under 356 and under 161 and in 311(2) is qualitatively different from the nature of exercise of power under 200. Therefore, those principles just cannot apply. What are judicially manageable standards are normally in the basic, in the domain of the executive. Normally in the domain of the executive, not in the domain of the legislature. Because legislative acts will be challenged in a court of law on violations of Part 3 or other lack of competence. So they are all judicially manageable standards. Take Article 14, Malas. Does Article 14 have a definition? No. But it's manageable. What is equality? You'll have to decide on a case-to-case basis whether equality has been violated or not. But that's manageable. Why? Because there's a fundamental principle of equality that runs through the Constitution itself. Arbitrariness cannot be defined. Liberty cannot be defined. Yet it is manageable. because it has constitutional implications on freedoms. Well, how do you say 200 has no manageable standards? What's the relevance of that? All standards which are not manageable are in the domain of the executive. What kind of crowd shelter should be? Should the court say you should pass directions that puja should be held here and not there? This is not manageable. This procession should not move in this direction or that direction. Not manageable by the court. But that's executive responsibility. But in the area of legislative responsibility, all standards are manageable because it's on the touchstone of the Constitution. Whether it's lack of authority, lack of competence, or violation of provisions of the Constitution. Therefore, this whole argument that it is not manageable. For example, let's take, for example, because I think it's a rule of evidence, actually. Manageable standards, not being able to manage standards is a rule of evidence because you don't have any evidence to actually manage it. Take, for example, a communication between husband and wife, solicitor and client. There are no manageable standards to deal with it. That's a rule of evidence. Because the court doesn't have the wherewithal, doesn't have the facts in its possession to be able to manage the situation. That's a rule of evidence. You don't have enough evidence. That's far removed from 200. Yes. Yeah. Just put it, I don't know how to resolve this. It's a difficult thing to do. All right, whatever, yeah. Now, let's kindly have a look at 2.4, this one, page 815.
Volume 2.4.
2.4,
Big number 815,
yes.
small number 3,
815, page 815.
small number 3.
There is no number 3. It's better the other way. Oh, that's right. Mhm.
Yes. We are utilizing the time for some other purpose.
No, I understand that. Well, let's kindly come to page 3, or rather 815, internal small page 3.
A big 815, small 3.
Yes. The constitutional premise for interpreting provisions is grounded in, though not limited to, constitutionalism, separation of powers, federalism, reasonableness, and democracy. And under the framework of separation of powers, the legislature legislates, the executive implements, and the judiciary adjudicates upon disputes relating to both ordinary and under the Constitution. This basic premise does not allow the executive to exercise primacy over lawmaking. The executive must function under the consistent limitations upon it by the Constitution. 53(1) of the Constitution states that the executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution. Now, whether this is the executive power will vest in him and be exercised either directly through officers subordinate to him in accordance with the Constitution. The officers also cannot act outside the Constitution. Therefore, this is the power to execute legislation. That's what it means. That's all that they are obliged to do. They can't thwart legislation.
Power to formally executive.
Yes, formally, naturally, formally.
But there lies some discussion with them, with the governor. That for some reason it may withhold and send it back to the legislature
Yes.
with a message.
Again, you are also using the word discretion. That's the moment you said that's his obligation.
Obligation,
Constitutional-
all right, obligation.
Yes.
That's the option he has to exercise.
He has to
Correct.
constitutionally exercise that option.
The word discretion is a problem for them.
No, it's not a problem, Manoj. What happens is, once you use, this was used loosely in other judgments, which is what has created the problem. For example, it is said 239(2) is a discretionary power. It's not.
You may say so, it's not discretionary that he has option A and B.
No, that's a constitutional obligation again, 239(2). Because he'll run the government, Manoj, through the union. He's a lieutenant governor. There was no, what's the discretion there? The concept of discretion is alien to 239(2). But yet this court, in passing, uses the word discretion. So this is what happens if you use the word, then you start interpreting.
He takes a decision.
He takes a decision.
Takes a decision.
That's right. That's what he is doing. That's his constitutional right or obligation. That's all I'm saying. What happens is if you use it, then in other cases when matters come up, they say the constitutional bench used it in this fashion, so use discretion. This is what happens.
But then that decision taken by him, whether it is justiciable or not,
Which one?
the governor's decision under 200.
Certainly not. If he assents to the bill, it is certainly
No,
not.
of course it is.
He takes no
The act is to be challenged.
Manoj, 200, he takes.
Or if he reserves this for the president,
That's not his decision. It's a recommendation.
that's his decision to.
No, Manoj. This is again a fallacy as a matter of law.
He may reserve it for the.
It is his opinion. I'm sorry. It is
For
a
justifiable reason.
decision and element.
Challenge.
A decision is an element of finality. It is opinion that this requires reconsideration of the president. That's all.
Declaration he has to make that he is reserving it for the president.
That's right.
Whether that declaration is justifiable or completely unjustified and unwarranted,
Well, first of all,
whether it can be challenged or not.
it can never be challenged.
It can never be challenged.
It can never be challenged. No question of it being challenged.
That's what the other side is also.
But
arguing.
that's no, there's nobody has ever challenged it, Mullah. Again, that's a chimera. Who has ever challenged it? He has also said assent is justice.
On your side, there are arguments which are conflicting or contradictory. You are taking a different stand. Dr. Singhvi took a different stand.
No. It's only on one point I'm taking a different stand with Dr. Singhvi. That's on the first. We're agreed. Yes. Yes, we're okay.
We'll hear them when
It's only on
they have a
one-
different
that-
stand or not.
But Mr.
Not now.
Mr. Shankararayan said that he is on a middle path.
No.
We're on both sides.
Both sides.
That is not justifiable.
Not just, how can assent be justiciable, Manoj? And who has ever,
Assent will not be justiciable once he grants it.
But
because
that's
that will
that's
become
the
a law.
argument made, that way assent is also justiciable. That's an argument made, but nobody ever said that assent is justiciable. Nobody has ever said that if you send it to the consideration of the president, that is justiciable. Nobody has ever said that. It's nobody's argument. It's been never argued in any case. It's something that he has assumed and said even that should be justiciable. It's not our case. It's nobody's case.
On one point, you are together. On the same page.
Which one, Mullah?
That is not justiciable.
Mullah, I am Kamath, Mullah. How can he be together with you? But he is not
Yes.
Baba Sahib. I may be Kamath.
Mr. Kamath used to oppose everyone.
It's not true.
And who is Mr. Naziruddin Ahmed?
Nazaruddin, yes.
No, Mr. Kamath, he did not oppose everything. It was Mr. Naziruddin Ahmed who opposed every suggestion of Dr. Ambedkar.
But Mr. Kamath used to oppose others as well, particularly Dr. Ambedkar.
So this principle is contained in the oath taken by the president. Mullahs, I've already shown that to your lordship. Oh, sorry, Mullahs. 5 is that in accordance with the constitution necessarily means that the executive power is exercised by the president is not absolute, as must function within the limitations and in accordance with the processes of the constitution. In other words, the exercise of executive power must be in alignment with the constitution. Then 6, this principle is also contained in the oath taken by the president. Well, I've already shown that to your lordships. Then paragraph 7. Once Article 73(1) and 162(1) define the executive power of the union and the state respectively. Under 73, the executive power of the union shall extend to matters with respect to which parliament has power to make laws. So it's limited to list 1 matters. And Mullahs, under 162, the executive power of the state shall extend to matters with respect to which legislature has the power to make laws. But it has no legislative function in that. Under 73 and 162, it is clear that the power to make law is vested exclusively in the legislature, and administrative power of executive is coterminous with legislative power. Further, both provisions begin with subject to the provisions of the Constitution. That's very important for us. So that executive power is also subject to the provisions of the Constitution. So therefore, that act of the executive will be subjected to scrutiny. And if it transgresses executive power, it will be struck down. So you cannot interpret the transgression as a power which allows only one provision in the Constitution, withholding consent, would be executive power that overrides the legislature. Goes against the very fundamentals of parliamentary democracy. Then under 74, there shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall in the exercise of his functions act in accordance with such advice. The provision stipulates that while discharging his functions entrusted to him under the Constitution, the President must act on the aid and advice of the Council of Ministers. My learned friend also Mullahs conceded when we were interpreting 111, if your lordships will remember, that when Parliament makes a law and sends it to the President, Mullahs, he has no power to withhold.
No,
He can send it back.
once.
That's all, but that's the very power here, Mullahs.
Once he can withhold.
Yes,
send
but
it
the
back.
word withholding consent is there. But there is no absolute power there to withhold. So how is it, Mullahs, that withholding consent he has no power, but the governor has? It can't be, Mullahs. See 111? That very expression is there. Yes. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or he withholds assent.
And thereafter the proviso.
And then it's provided that the President may as soon as possible, same thing, Mullahs. So therefore, here withholding consent is not absolute, no absolute power to withhold consent. But the interpretation is in 200 he has that absolute power. So the same expression used in 2 articles would be interpreted differently by this court. That's what my learned friend wants your lordships to do.
Because of the difference in the executive power.
Yes, it's the same thing. And Manoj, kindly see, I'm not that, now that I'm in that, read 200 once again with me. It's very interesting. The second proviso to 200. It's very interesting. Second proviso to 200. I'm digressing a bit, Manoj. It just occurred to me. Sorry. Provided further that the governor shall not assent to, but shall reserve for the consideration of the president any bill which in the opinion of the governor would, if it became law, so derogate from the powers of the High Court. Shall not assent to.
Yes.
Different from withholding assent. It's my learned friend's argument, withholding assent is shall not assent to. Permanently. Second.
So according to you, where an absolute power was intended by the Constitution
Yes,
not to give assent,
yes,
this specific mention has been made by the Constitution.
that's right, that's right.
In the Constitution.
In the Constitution.
Therefore, that can't be added in the first proviso.
Absolutely.
Or in the main.
That's correct. The concept of withholding is itself a temporary concept. Manoj. Withhold, send it back. Withhold, send it to the president. Right? That act of withholding is an act
For that, these two
only
options.
for that only. I'll do it tomorrow, Manoj, now.
There was a request from your side that somebody wanted to, I think from state of Himachal Pradesh.
What-
Who is that? I think it was. Huh?
Himachal, Manoj, not Madhya Pradesh.
Himachal.
I think Mr.
Yeah, we are giving him time, Manoj.
Huh?
We'll give him
Sibal is
time.
for
No,
West
he
Bengal.
has a personal difficulty next week, so he wanted some precedence tomorrow. That we'll have to be considered.
I will. He's an old
I think
colleague of
Mr.
mine.
I deal with him.
Yes, I can't deal with him. He's elder to him. Manoj.
Some marriage in the family and I was,
Yes. Mr. Sibal appeared for West Bengal.
no. For Himachal Pradesh, Mr.
No. Mr. Sibal
Simple appears for West Bengal, yes.
He has given up Karnataka.
Because otherwise, Manoj, my colleague Subramanian Swami, Gopal Subramanian Swami, he's also a colleague, Manoj, so that's all right. He
No.
will not get time.
Do you want him also to come here?
He would have, Manoj, except that he's some difficulty. Obliged, Manoj, deeply obliged.